Great physiology. Great physiology. Lordship, in item number 28 to 46, I would like to pray for some time. No, in fact, what has happened in
Let the item be called, we'll see to it. Let the item be called.
Wait.
Let's figure out what matter it is about.
Yes.
One time be.
Item 2 for motion.
Lordship.
Yes.
Lordship, in this case, shifting is there.
Naburuddin. Do you have material for shifting or you want to produce something?
We have to produce also. One Gambura has also came in this case, Lordship, but he said that he knows the father of the
Gamura of which village? A later village or earlier village?
earlier village, Lordship.
How does he know where that man had shifted from his village? Suppose
Yes,
X is your neighbor today. You know the X very well.
yes.
X goes away somewhere else. How do you know where X had gone? That will be most likely to be hearsay. Somebody say or X himself says that I'm going there.
Yes.
This is where we are having the difficulty.
We'll file additional affidavit.
Why don't you think of some better evidences? There are materials which
Yes,
you can prove. At least one thing we indicated that those voters list, upward, downward of that 2 places, that is one good indication. And think of some more material.
Yes, Lord.
I must say, H. Betala, learned counsel for the petitioner, seeks for an adjournment to explore whether any further material is available to substantiate that the petitioner, family of the petitioner had shifted from village
Sargaon to Bheragaon.
Saragaon to Veragaon.
Yes, sir.
Saragaon to Veragaon, one more matter is there.
Lots of matters are there, Lordship.
No,
There-
no, especially these 2 villages.
Yes, Lordship.
Because I remember the 2 names, Saragaon and Veragaon.
Yes, Lordship.
More petitions are there.
Yes, Lordship.
Item 3.
It's item 3. Intends to bring from a certificate from the Gambura village, Saragaon to same Saragaon to Veragaon.
Yes,
Or
Lordship.
this time to
Satra Kannada.
Satra Kannada.
Lordship, we have filed the affidavit, Lordship.
In the form of a certificate from the government to establish that there was. Again, the same problem will be there. No, you just physically imagine a situation.
Lordship, we have filed already additional affidavit in this case.
Understand what material you have brought?
Neighbors are there.
Neighbors of.
Neighbors of
No,
both
this
the
is the
villages.
difficulty. You just physically imagine a situation. Take it to be your own house. You have a neighbor there. You may know the neighbor very well. Neighbor goes away. How can you vouch for where the neighbor had gone unless you make a statement that after he went, I also visited his house once, so and so village? Then maybe, as a good early friendly neighbor, later on you
Yes,
happen to visit his house as a guest. Then you may give the evidence that I know he is there. Otherwise, this statement will be hearsay. You have heard that he had gone to X village. Similarly, the Gambura or any person of the new village can vouch for the situation that from this day, this man is living in a village, I know him.
Lordship, we have mentioned
From-
this in our additional affidavit.
What you have mentioned?
Lordship,
That you visited his house later on.
yes, Lordship, that on, may I read, Lordship?
Yes, please.
That on various occasion and family functions, I am invited by the family members of the opposite party, and I used to visit the paternal house of the opposite party on such invitations.
In that new place.
Yes, Lordship.
Yes, Mr. Pine. Now we have to test the veracity of this evidence,
Yes.
whether they have
Yes.
correctly said or falsely stated.
Yes.
What is your name? Additional affidavit on record,
Yes, Lordship, page 96. Lordship.
96.
I have to check the records whether this.
96 is here.
Yes.
96. Who is he? This one.
He is the former Gangura lordship.
I was the former Gambur of Sargaon. But I have personal knowledge about both the villages, Aligaon and never been the district. of this. Who is the petitioner? Some lady or unlady? Miss, this is shifting after marriage.
Yes.
This is
lordship.
a shifting of the entire family, or it's a shifting after marriage of this lady?
Entire family lordship.
Entire family.
Yes.
Where have you stated that the entire family had shifted?
Point nine, page number 96 lordship.
96.
Yes, lordship. Point number 10.
On various occasions and family functions, I'm invited by the family members of the, and I used to visit the paternal house on such occasions. Which village? They shifted from Sargaon to? They have shifted from Sargaon to Saprakanara.
Yes, lordship.
The family shifted.
Yes, lordship.
And after marriage, this lady had gone to her, this thing.
But link between the father and the Gangura, the former Gangura.
We understand.
Yes, lord.
For this lady, there will be two shifting. One family shifting from Satara to that, no, Sargaon to Satara.
Yes, lordship.
And after marriage from Satara, where whichever village she is married in.
Yes, lordship.
This paragraph 10 pertains to shifting from Sargaon to Satara.
Yes, lordship.
Where is it stated?
Lordship, her husband's evidence also we intends to file before the honorable, before the learned tribunal lordship. Page
Husband,
79.
how does he know where the family?
Husband will know.
See, the husband,
Yes, lordship.
if the marriage is arranged, he will come to know from which village his wife is from.
Yes, lordship.
How will he know where the family of the wife resided earlier?
Because lordship,
No, because that will be hearsay. This is what.
he is also from Sargaon, lordship. Husband is also from Sargaon and
And married at Satara Kinara.
yes, lordship.
Find a more detailed proper affidavit so that we can appreciate
Yes,
it.
lordship. Page 83, we have annexed the voters list of his father also from that village.
No. If you want us to take note of certain evidence, why didn't you state it properly? That a person deposing before the tribunal is a resident of Sargaon.
Yes, lordship.
By virtue of being resident or being neighbor or whatever it is, he personally knows the family of this one who were resident of Sargaon. Then they had shifted from Sargaon to Satara.
Yes.
After the shifting, he happened to marry the girl from that family. So he knows that it is the same family who is in Satara.
Yes, lordship.
This is a complete evidence. No one can disturb you anymore
Yes, lordship.
unless they rebut that evidence in some cross or something.
Yes, lordship.
Otherwise, some gaps, some loose ends remain. However, it is possible what you are saying is right, but that has to come in specific statements in deposition.
Lordship, my humble prayer is if this matter is remanded back, we'll file this before the.
Why don't you file it here? We'll appreciate and then remand it back.
Yes, lordship.
It is stated that the husband of the petitioner is a resident of village Satara, where the family of the petitioner earlier resided, and therefore, by virtue of being a resident of the same village, the husband of the petitioner knew the family of the petitioner while they were residing at Satara. It is also stated that subsequently the family of the petitioner shifted to village Satara Satra Kanara. After the family had shifted to village Satra Kanara, the husband of the petitioner had married her. And therefore, he has the complete knowledge that this is the same family which earlier resided at village Sargaon and later on shifted to village Satra Kanara. Appropriate affidavit may be filed, stating in precise terms the aforesaid fact if the petitioner intends to rely upon the same.
Yes, Lord. Husband were also shifted from in the same year, Lordship, because of the erosion. And he had stated, but the
This
deposition.
is that means his evidence will not be reliable. It's like the same thing the petitioner herself says.
But he has produced the material, Lordship, to show that, yes, they had shifted and they are from that village.
We
Sir.
have not much time for all
Yes,
these matters.
Much
If we are giving you the opportunity, if you want to, you file a complete evidence
Lord.
which will establish that the family had shifted from one village to the other village.
Yes.
Item 4,
And if you don't, till evidence will be short, we'll dismiss the petition.
No, no.
If you want to take the opportunity, you can avail it, up to you. Instead of trying to force it on us, that please accept the half-baked evidence to be the complete evidence, you won't succeed in that.
Yes.
Okay.
Much.
The petitioner may file any further evidence that the family of the petitioner has shifted from village Satara to village Sargaon to
Sargaon to
Satra
Satra
Kanara. Madam, the shifting is a very sensitive issue. It's a fact which has to be established. How can we establish? What are the possible means to establish this fact that one family earlier resided in place X, later on, same family shifted to place Y? How will you prove it?
One is Lordship.
One,
Neighbor.
your claim is, it's only remains a claim. How will you prove it?
Through documents, Lordship, via.
What
photos.
documents? Even if it is document, the question will remain, that document pertains to this person or some other person having the same name.
Upward and downward voters list.
This is one only indication. That is, we are only suggesting
Yes,
it you. Otherwise, how will you prove it? See, people of this community, suppose there cannot be any presumption that everybody has shifted or this particular person has shifted. The community may have the habit of shifting from one place to another. But that doesn't mean because of that habit of the community, this person had also shifted. It's only a possibility. Say Assamese people take fish. Will it mean that every person takes fish? Or if the question arises whether Rex taxpayer or not, you'll have to specially prove it. This is the principle we are trying to put it across you. Or else there is no public record of these things. So you'll not get any information from any public record.
Yes.
Only way out is a person reliable who can explain the circumstance from which he had acquired this knowledge. That person will come and depose. That's the only way out for you.
Yes.
But it should be a person who will first establish that he has the personal knowledge of this fact. And before that, he'll also have to establish the circumstance in which he acquired that knowledge. Anything short of this will not be evidence. It will remain only a claim. So you apply your mind and see what evidence material you can bring. Otherwise, we can convert your claims into a judgment and accept it.
Yes.
Item 4 is personally who is father.
Lordship, sifting is there, Lordship, and we have filed the additional affidavit, Lordship.
Now, straight away tell us before going to the event, what have you brought? What material you have brought?
Lordship, in this, we had seen the birth of the petitioner, Lordship.
Seen the wife of the petitioner.
Birth of the petitioner.
Sorry.
Birth of the petitioner,
Seen the birth of the petitioner. Where?
where they were earlier resided.
Seen the birth of the petitioner in the earlier village.
Yes, Lord.
How does he know to which village they had later on shifted?
Yes, Lordship. In page 136, I have explained.
No, please orally say us something
Yes, Lord.
before us. How does he know? Suppose he had seen a person to have born in his neighborhood, he knows, yes, this is that person. That person later on went to some other place. How does he know where that person went? He may at the best know that he went,
Yes, Lord.
but where he went, how does he know?
Because they are having a relationship with them as a neighbor. They used to invite, they have a relationship with him. So
Invite.
Yes, Lordship.
So now this common plea is coming that I'm always invited to his house.
We have not written Lordship invite, but they are in link, we have written.
See, I'm giving you a personal example of mine. We had a neighbor, immediate neighbor,
Yes.
just across the road. We knew that family very well. One day the family comes and says, we are moving up to Guwahati, we are going to Bangalore. Can I now depose before any authority that that family is the same family within Bangalore now? I cannot.
Until and unless we
Why?
visit.
Because
them.
my source of knowledge is only at the time of leaving they told me. It's a hearsay. Suppose the circumstance is different, that later on I am having contact with them. I went to Bangalore, they invited me to his house and I saw them there. Went to their house, had a cup of tea, came out and met them there. That will be evidence.
Yes.
Then I can vouch for it, that it is the same person who was my earlier neighbor is now residing in Bangalore because I had gone to their house. So your evidence has to be
Yes, Lord.
on that principle.
Lordship, the earlier neighbor, in this case, Lordship, my neighbor, after my shifting, they also shifted in that village.
This is the difficulty, madam. Both of them are having a common
Same.
purpose.
Yes.
So your neighbor will vouch for you in your proceeding and you will go and vouch for him in his proceeding. This is not evidence.
Yes, Lordship.
Understood? That's why we are putting it across you. So both of you can be in collision. Both of you shifted, no one knows, or may have come from Bangladesh. Let both of us take the same common stand that we are in X village of Assam and shifted there. When there is a proceeding against you, I'll go and give evidence. When it is me, you come and give evidence. So, So therefore, I say the person giving the evidence must be trustworthy, reliable, and
Yes, Lordship.
should also be a person who would be acceptable for this evidence.
Yes,
What do you want to do now?
1 week time, Lordship.
See, we have indicated
Yes,
everything. You work it out and you bring materials. So otherwise, adjourn on the prayer of heaven. Can you conceive of any other situation?
Item 5,
Pune?
May I please?
Yes.
My lord, if I'm not wrong, this matter has been wrongly listed, my lord.
If you are not wrong, matter wrongly listed.
My lord.
Why?
It is a matter related to bench two, my lord, civil bench two matter.
Single bench matter.
My lord. My lord.
It stated that this matter pertains to the single bench. Registry to verify and list accordingly.
Some urgency is there, not wrongly listed. Date,
You can make a request. Informally, a message will be sent, but we can't pass any order.
my lord.
item 6 for admission.
Yes, 6. Petitioner relies on the birth certificate issued by the secretary. Yes, original records you have.
Last time asked to produce this one. This is the
No,
original.
original records, not the original certificate given to you.
My lord,
No, because we are finding a little something to be looked into. Because this is a certificate issued by the Gaon Panchayat.
my lord,
Does the Gaon Panchayat under the law issue any birth certificate?
my lord, but the certificate shows that government of Assam with the Mukhya Panjiyok, chief registrar. It is there is a seal of the Gaon Panchayat on it.
So it is issued by the government of Assam.
My lord, that we have to ascertain because my
So
lord,
that's why we required the health department also.
yes, my lord,
To
because now health is a transferred subject, so we have communicated to the joint director of
Given some more time.
BTC, my
Mr.
lord.
DP Bora, Land Council
My
for the health.
No, my lord, the BTC has to produce, my lord. Because now that is a transfer subject that is under the BTC authority.
We have no control over BTC.
So BTC may be directed, my lord, and Mr. S. Bora, my lord. Mr. Santanu Bora is there for BTC, my lord.
So health is a transfer subject for BTC,
Yes,
and
ma'am.
these records will be with BTC now.
BTC, joint director of BTC.
It is stated that the health is a transfer subject in the under the BTC. And therefore, the information required by the order dated 18/5/2023 can only be provided by the authorities under the BTC. Accordingly, a copy of the earlier order of 18/5/2023 and today's order be provided to
Mr. S. Bora.
provided to Mr. DP Bora, Land Council Health Department, for onward transmission to the
Yes.
Learned Standing Council of the BTC
Yes.
for doing the needful.
Oblige, my lord.
Interim order may kindly continue.
Interim order continue.
Kindly oblige your lord.
Item 7,
Item 7, Minoti Roy, yes, sir. Here is the status report of the. What that matter?
Yes, Lordship.
Have you conferred with that policeman? One who was before us.
Deepak Soikia.
Have you conferred with him? Is he aware of the? Is he aware of the implications?
No, Lordship, I think no.
Hmm.
He's a township.
Is he aware of the implication of saying something happened in the police custody and are aware of denying it, and ultimately an inquiry will be held? And if it is found that it is he had done it, what will be the implication in the two circumstances? Is he aware?
I think no.
Hmm?
His counsel is dear Lordship, he will.
You represent that Saikia police person. Are you aware of the two consequences?
Not yet.
Suppose there is a candid admission, yes, something wrong may have happened in the police station. The implication thereof in respect of this man. And if it is a complete denial and a thorough inquiry is made, and the result of the inquiry reveals that it is he had done it, are you aware of the two different implications?
So I don't say.
Hmm?
I
Is
am
your
aware.
client aware of the two implications?
Okay.
He is aware
He's aware,
and he wants to face it.
Right.
Very good.
but he still denied. Like,
Because materials coming
Right.
in a things may not be very rosy for him. If he's aware, it's okay. We are just asking you. We're not suggesting anything. We're just putting it across. The two implications may be different.
Lordship, what he stated in the before your Lordship, still he is on his.
It's on your legal advice or it is his own
No, no,
view?
no. On
Own view. Because normally lawyers always put legal advice to an accused in any criminal matter. Only deny, don't do anything beyond denial. Little realizing that something less of denial may have led to a lesser kind of an order against him. Because in many 302 cases, we have noticed that the accused never takes advantage of section 313 CRPC and they only deny.
Lordship.
And because of that, they lose a very good opportunity of getting something reduced. Where is the release document of this person? When he was brought to the police station, suppose I go by your events, he was released on 25/2/2016. Where is the document by which he was released? Suppose a person is brought to the police station, it cannot be unrecorded. That like a guest coming to your house, a person comes in and whenever he feels like he goes away. Everything has to be recorded. Even if the person is released, given in the custody of the father, there must be something, something must be there. Where is that document? Release is your GD entry. How do you know? No, how you know?
Submitted.
From where you were in custody of the records? You may be engaged, but how did you have privy to these records? Now we are not holding that office.
Submitted by the Home Department.
Mr. Counsel, it's a serious matter. How do you happen to have privy of the records to be maintained by the government advocate? You are here as a, in person you are before the court. You are not as a part of the government, although you may be a policeman. How did you have access to their records? Under what authority? You know, you'll have to explain now. Under what authority you have taken access of the public record? You cannot. We, the petitioner, cannot have access to the public record unless shown by the government advocate. You also cannot. Then from where are you speaking? Just now we are holding a paper. Whose affidavit?
Respondent number 7 has been submitted.
Sorry, who is respondent number 7?
I am representing.
But you were holding some public record. Just now GD entry you say. Where was the record you produced the other day? The status report of the SP, where is it? According to his victim was picked up from the house. Yeah. Change code. Is the SP making an impartial inquiry or he is trying to protect the police people? Ask him to come personally. SP Bongaigaon.
Yes, Lord.
Ask him to come personally. It appears that all the police are coming together and they're trying to protect each other. And the one person who had given a correct statement, now he is also being influenced to change his statement. Ask your SP. Everything is on record before us. And we also remember everything. Plus, these proceedings are on video recording. It's also recorded also. everybody will be in a more deeper trouble because of trying to falsely protect something. That will be now a much more serious offense than the actual beating if given by somebody to this boy. That offense may have been a much more lighter offense. Trying to bring in false material and try to protect is a much graver offense, which may include many other people now. Are your people aware of it? They are aware of it, but they still like to protect
No, Lordship.
and bring in false material before the court.
No, Lordship, as the SP provided me that, that is I'm submitting before the honorable court.
Ask him to come, SP. That's why in the very beginning we indicated, had somebody been candid enough and actually admitted, yes, something little out of the order had happened, the implication would have been much more lighter. But more and more you are trying to protect yourself by bringing in false material. The implications are becoming more and more severe at every stage. The updated status report is accepted, kept on record, resealed, and kept in the custody of the court. The SP Bongaigaon to remain personally present on the next returnable date. Response.
May I get back the status report, Lordship?
Sorry,
Status report.
no, we have taken
No,
custody of it.
Other day I had submitted before the honorable court and today.
That you
also-
can take. We already have it on
Yes,
the
yes.
report. Itu reseal ko ifale pwede po. Hello. Tomorrow.
Lordship.
Ask him to come tomorrow. Itu cover disil lagi. itu खोला के क्यों दिया सील कवर दिया अच्छा
Item 8,
Here, Pandina.
CID inquiry regime, including the SP. Next stage. To investigate even SP. Yes, Hazrat Ali.
Lordship, date 8. 66 Buddha listed.
Sorry.
28. Lordship.
38.
66 Buddha listed. His father name is Yusuf Ali and grandfather Asraf. Also,
28 Yusuf Ali. He is the father or grandfather?
father and grandfather.
Father and grandfather both Yusuf Ali.
Yusuf Ali, father and Asraf, grandfather.
Sorry. We are asking you the question, Yusuf Ali is the father or grandfather, and you are saying both.
Father.
Please pay a little more attention to the court proceedings. How can one man be both grandfather and father? Who is Yusuf Ali?
for his father. of Bishop.
Father, okay.
So in 1970,
Let
He
it be
started
70. Which document will show Isab Ali is the father?
page 37. Hazrat Ali, 58, Hazrat Ali, son of 57.
Amul's and who, mother.
Mother.
What happened to Isab?
From
The petitioner to produce the complete voters list of 1966 to 1993 of village Tengaguri Kosarigao.
The election commission.
Election Commission to produce the origin of the 1966 voters list of village Tengaguri Kosarigao.
Item 9,
I use my fullness. Who is the father of one states that no material is ever proved that it is a daughter of Gopal. So,
Your lordship, I was asked on the previous day, I was asked to put.
Have you seen the order of?
29/5/2023. Irudivo. List next week for the report of the SP border as indicated in the order dated. What's the date of order, Mr. Pai? 29/5/2023. Next week.
item 10,
Yes. Yes, sir. How do you perceive these situations?
There is some judgment earlier dealing with similar situation. Even I have not gone to just now. My learned friend is.
Acha, it's some taken up matter.
It's not sufficient. My learned friend was there earlier in a similar situation.
So you do the same thing. Hmm. Our question is a little larger than this.
Lot of issues are coming one after this.
Ha.
I think.
This because another family member is relying on the earlier order, so it has come to the notice of the court. Fine, we will so moto issue notice, set aside, send it back. It takes care of only one case. But if this is a tendency of the tribunals, what about the others?
For the timing.
No, once you do this, it will be closed. Aha. And it is not one. In fact, other day, Mr. Paying had given me some orders also, and we had to go through it. Then again, we'll examine in what manner these people are declared to be citizens. Because wherever they declared foreigner, it is about 4 to 5 pages order. Everything is discussed, these disbelief, discrepancy, nothing is accepted, you are declared foreigner. But wherever you are declared a citizen, it's hardly 2 pages. And the only thing is that, in my opinion, you just say, this man produced X, Y, Z, these materials, peruse the material. In my opinion, he is a citizen. How those materials show that he is a citizen is nowhere discussed, nor the reason is given.
One suggestion I think is in this way, madam. On the admissive side, 4 to 5 cases from that particular tribunal from where this is coming. 4 to 5 cases where the person has been declared to be not a foreigner. Maybe examined by the registry.
Let us do one thing. We give interim protection to this person.
Minor.
And Mr. Day, you also act as an amicus also. Along with representing your client. Here, let us pass some orders here only. Otherwise, there has to be some continuity in the monitoring.
This is one way I think, minor, that.
And this petitioner, we give him all the interim protection for the time being.
Yes.
You don't worry.
And on the admissive side, my lord, if 4 or 5 cases are taken
No,
up.
why administrative? Let us pass on the judicial side.
4 or 5, because this will require some time.
Administrative memo again.
Who does government? Legal.
We do one thing.
Fine.
We direct all the tribunals to give 10 orders where they have declared somebody to be Indian citizen. All the tribunals. Then they will choose. They'll choose only the best of them. The worst ones will not be given.
5 cases we do in my umbrella. 5
Uh,
cases from each tribunal, because somebody.
okay,
will have to-
from instead of 10, let us make it 5.
And
But if you leave it to the discretion of the tribunal, they'll give the 5 of the best written orders. What will happen to the
let it be 10. Let it be 10 then.
at least let us start with their best written orders
Minor.
only.
As a test case, my lord, if from this tribunal, let 10 cases be called for first. if your lordship finds really there is something like this, then otherwise it will be a very Herculean job, my lord. All these tribunals,
Job,
10 cases from each tribunal.
see, if the law requires, job has to be done.
That is,
Herculean doesn't mean you shirk away.
correct. And I am told there is a screening committee in the.
Everything exists, but things are not working. That's a difficulty.
Their judgments are monitored.
There are no dearth of systems being put in place. Difficulty is the
intensely.
desired results are not coming.
All right. This pass. In his case, lordship pass in order.
Heard Mr. R. Dev, learned counsel for the petitioners. Also heard Mr. D. Mojumdar, learned additional senior advocate for the state of Assam, along with Mr. G. Paing, learned counsel for the Home Department of the Government of Assam. But it's over, it will be one. Circumstance. The petitioner, Kasem Ali, had been referred to the, which order, Mr. D?
Lordship at page 60 below.
Had been referred, 16, had been referred to the Foreigners Tribunal number 11 at Borpeta for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number BPT/11 bracket close FT 879/2016 by the opinion dated 28/3/2019, the petitioner had been declared to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ petition, the petitioner takes a stand that the petitioner is Muhammad Kasem Ali, son of Lalu Fakir. And in respect of Lalu Fakir, there is a prior opinion rendered by the
Page 19.
Foreigners Tribunal number 8 Borpeta in FT case number 264/2015, wherein he was declared to be an Indian citizen. Accordingly, a claim is made that as the father had been declared to be an Indian citizen, therefore, consequently, the son would also, there is also a requirement to declare the son to be a foreigner. As the entire claim of the writ petitioner is based on the earlier opinion dated 30/4/2016 in respect of his father Lalu Fakir in FT case number 264/2015, we deemed it appropriate to peruse the said order. A perusal of the said order makes it discernible that the petitioner had relied upon, had filed written state that Lalu Fakir in FT case number 264/2015 had filed the written statement along with photocopies of some documents to be relied by him, which included a voters list of 1966 of village Menisimla, where his name appears at, where the name of his father, Joban Fakir, appears at serial 146, as well as the voters list of 1970 of village village Menusimla, where the name of the father of his father, Joban Fakir, appears at serial 156. The petitioner therein, Lalu Fakir also relied on a voters list of 1989 of village Bandor Khoa, wherein it was claimed that his own name appears at serial 807. Lalu Fakir, in his evidence before the tribunal, had stated that his father, Joban Fakir, had shifted his residence from village Menusimla to village Bandor Khoa due to erosion. The tribunal, a certificate of the Gaumbura of village Menusimla and the Gaumbura of village Bandor Khoa was also relied upon. The tribunal, in paragraph 12 of its opinion, dated 30/4/2016, arrived at its conclusion as extracted. A reading of the aforementioned extracted conclusion of the tribunal makes it discernible that the tribunal relied on the voters list of 1966-1970 of village Menusimla, which contains the name of the acclaimed father of Lalu Fakir, namely Joban Fakir, and the voters list of 1989 of village Bandor Khoa, and arrived at its conclusion, and also some land document, and arrived at its conclusion that it appeared to the tribunal that the father of the petitioner came to Assam before 25/3/1971. No reasoning is given, nor any appreciation of the materials on record is discernible in the opinion of the tribunal, other than the conclusion that it appeared to the tribunal that the father of Lalu Fakir came to India prior to 25/3/1971. Accordingly, in paragraph 14, the tribunal concluded that the Lalu Fakir had successfully proved that he and his family members entered Assam prior to 25/3/19, and he is not a foreigner. In a similar circumstance, when this court in WPC 4540/2017 had noticed that some family members of a proceedee had been declared to be an Indian citizen without appropriate appreciation of the evidence and without providing any reason as to why the tribunal deemed it appropriate that the person is not a foreigner, suo motu notices were issued in respect of the other family members by an order dated 29/2017 in WPC 4540/2017. The order dated so and so is extracted as below. Order dated so and so in WBC 49.1. Upon issuing suo motu notices in respect of the other family members in WPC 4540/2017, comma, a final order was passed. Final order dated 6/3/2018 was passed in all such suo motu taken up writ petitions, as well as WPC 4540/2017, wherein the orders declaring the family members of the petitioner in WPC 4540/2017 was set aside and the matter remanded back to the tribunal for fresh and appropriate adjudication. As noticed in the order dated 29/2017 in WBC 4540/2017, as well as in the facts and circumstance of the present writ petition, wherein an opinion dated 30/4/2016 in FT case number 264/2015 had been relied upon, wherein the father of the present writ petitioner was declared to be an Indian citizen. Last sentence. Comma, a disturbing trend is noticed that wherever a person referred to the foreigners tribunal is declared to be a foreigner, a much detailed order is passed by making an endeavor to also provide reasons thereof. But when a person is declared by the foreign tribunals to be an Indian citizen, the requirement of giving appropriate appreciation of the evidence on record and giving a reason order is not adhered to. And only by providing a single sentence that in the opinion of the tribunal, the person concerned is a citizen, comma, is accordingly declared so. As an existing trend, as stated above, is noticed, comma, we are of the view that it would be appropriate to call for 5 opinions from every tribunal in the state of Assam, by which the proceedee concerned had been declared to be an Indian citizen, to enable the court to examine as to what reasoning were provided in such opinions where the proceedees were declared to be Indian citizens. A copy of this order is provided to Mr. J. Paing, then Council of Home Department, for doing the needful and to circulate amongst the tribunals, so that 5 orders by each and every tribunal declaring persons to be Indian citizens be made available to the court for its examination, based on after 2 weeks. In the meantime, the present writ, no coercive action be taken against the present writ petitioner.
But some tribunals are very new, my lord, so they may not have 5 judgment opinions of declaring Indians. As
If
whatever
a given tribunal has not rendered 5 opinions declared anybody to be an Indian citizen, such tribunals may provide only those opinions where they are declared to be Indian citizens and need not adhere to the requirement of providing 5 opinions. If a given tribunal has not declared anybody a citizen, he is not required to say. He can only make a statement that in my tribunal, I have not declared anybody to be Indian citizen. Response also.
Item 11.
May please your lordship, the petitioner is the Durlop Roy, alias Durlop Chandra Roy lordship. His father's name is recorded in the 1956 voter list. Page 64 lordship.
Sorry.
Page 64.
Uday Chandra Roy.
Uday Chandra Roy is father and Surbala is the mother.
Because it like it. People didn't know person.
64.
And the mother is Surbala.
Surbala.
Okay.
And
Which document
lordship, the
is
voter list,
Uday is the father of Durlop.
Surbala is mother. And Uday Chandra Roy is the father.
We understand. Which document will show Uday Chandra is the father?
The lordship, the Jamabandi copy, lordship,
Page number.
page, Barnacular page 82, lordship. The lordship, the remarks column, the month of ball, lordship, the last portion. Short means sitar uparat,
So where you were reading? The remarks for Montego.
month of lordship.
Montego, which Montego?
The short means sitar uparat.
No, there are two orders referred,
Below order, lordship.
the one below,
Lordship,
that order dated 17/2/95, that one.
lordship, 70 to 95.
Tarikor-
Tarikar Uttariya Putre, Patar Atat. My name is Durlop. 5 numbers.
Who is the Patadar?
After the lordship, my father,
It is only written. Tarikor hukum mate omuk omuk putre Patadaror stolo. Who is the Patadar?
the Patar number 1 lordship, Uday Chandra Roy lordship, my father.
The order does not write.
Uday Chandra Roy, my father. lordship.
And the land is located in which village? Gaon. Bora,
Boramari, nonke.
Bora,
Boramari,
Boramari.
Pam. Same village lordship.
Boramari, and this is Boramari upon Nongkeson. Yes, Mr. Sharma. Let me go back. Heard Mr. N. Ahmed, Land Counsel for the petitioner. Also heard Mr. V. Sharma. The petitioner Durlop Roy had been referred to the Foreigners Tribunal number 1,
One lordship.
Morigaon, for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FTC case number 203/2007. Tribunal rendered an opinion dated 3/8/2011 declaring the petitioner to be a foreigner. Being aggrieved this writ petition in the writ proceeding, the petitioner relies upon the voters list of 1956 of village Boramari Nongke, Moza Mayang, police station Morigaon in the present Morigaon district. which contains the name of Ujay Chandra Roy, son of Adhar, at serial 28, and that of Surbala, wife of Uday, at serial 30, where both are shown to be residing in the same house number 15. And it is claimed that Uday Chandra Roy is the father of the petitioner. To substantiate that Uday Chandra Roy is the father, reliance is placed on a Jamabandi in respect of a plot of land at village Boramari, Palm, wherein, as per the order of the circle officer dated 17/2/1995, land had been mutated in place of the Patadar in favor of, amongst others, Durlov. Sundar Roy is not there, only Durlov is there. Durlov. In the information as regards the Patadar contained in the same Jamabandi, from the information, it is noticed that the name of Sri Uday Chandra Roy, son of Adhar, had been struck off and in his place replaced by, amongst other, Durlov, son of Uday. If the information contained in the voters list of 1956 of village Boramari Nongke and Jamabandi of the plot of land at village Boramari Farm are correct and acceptable, the petitioner may have discharged the burden under Section 9 of the Foreigners Act, that Foreigners 1946, that he is a citizen. In view of the remanded back to the tribunal to examine the voters list as well as the only and pass a reason order. The Home Department may make their own verification and submit report to the tribunal if so advised.
Item 12.
May please your lordship, the petitioner's father's name is recorded in the 1965 voter list.
Father's name is 1965.
The page 28 lordship, 27 and 28 lordship. Osimundal is father. Joriman Mandal is mother.
Sorry, page number 28.
28 lordship.
Who is the father? Osimondol.
Osimundal.
Khudnabari Kotha.
Patnabari father.
Osimondol father.
17 voter list.
And Joriman mother.
Mother lordship.
Which document will show Osimondol is the father?
Lordship, the page lordship, Damabandi copy page 39 lordship. Same village Khudnabari father lordship. My name Montobbo colon remark colon last order.
Osimondol. Where is the name of Osimondol?
Osimundal is not there. My brother's name is there. My name is along with my brother's.
How do you know he's the brother is the son of Osimondol?
This complete order is not there.
Your Osimondol is a citizen. If we accept that page 28. Now you have to show you are son of Osimondol. If you say that my name is along with my brother, you and your brother both will have to show that they are sons of Osimondol.
This part is not there, lordship, the order.
I have noticed it. That's why I'm asking you this question. You bring any, the petitioner may produce any material which may show that he is the son of Osimondol of the voters list of 1965 of village Khudnabari Pathar.
Item 13.
13. Gopendra Namasudra. You're producing some old document.
very old document, certificate of registration. Because his father has migrated from East Pakistan. Which this document he has not exhibited before the learned tribunal.
So your statement till now shows you are a foreigner.
I'm not a foreigner. My father certificate of
No,
registration.
your statements till now shows you are a foreigner.
May I pleases your lordships, my lord?
You
My
have
father
missed out
is,
one thing. Migrated prior to 71. You did not say that.
it's certificate of registration of 1956.
You did not say that. You said only migrated from Pakistan.
East Pakistan.
Anyway, so you are relying on this one.
Yes, lordship, which it was not exhibited before
Very
the
well, doesn't matter.
learned tribunal.
Who is the father?
Sumanto.
Huh?
Sumanto Namasudra. It's written in fountain pen and that ink also is very,
No, we have noticed that, but no, very, very well. He is some Namasutra, no doubt, starting with S, but Sumanto or not, you don't know. Anyway, now Gopendra is the son of that person.
yes, lordship.
And where does he stay? Do you have any other document?
Yes, lordship. His school certificate is there, lordship. Page 58, lordship.
Namasutra to her. What's the name of the father?
Sumanto.
It's not Sumanto, it is Santa or something of that kind.
Sumanta.
No, it is S-H-A. S-H-A-N. Till that much I can read.
Son of Sunaram.
But it is leading to Shanta or something. It's not leading to Sumanto.
Then
Registering authority is Kara Singh.
somehow they have preserved that because even in 83 there was violence. They stayed in camp. Those documents were there.
Impression on the guarantee made in presence of the some guarantor to Sonara now. No, it will guarantee it is Sonara. It is guarantor. Some person the guarantee made in presence of the Was this document subjected to some treatment?
Because they
You know,
were
different treatments are available. If you put it on top of the fire where the smoke will be coming out,
no, not
document
that.
appearance will look little different.
Dealing with this sort of.
If you fumigate it in a particular manner, the ink takes a different appearance. Was it subjected to any such treatment?
I don't think so, lordship. Reason is that one
No,
reason.
before you say your reason, we are putting our reason why we are asking this question. If you look at the signature,
Yes, lordship.
it's green ink. Normally, green fades the earliest.
Hmm.
Blue is little more permanent than green.
Hmm.
Green ink is very clear. You can almost read the name also, although it's a signature. Then the name of the guarantor, Sonaram Namachudra, that is also very clear. So this man also must have signed with the same pen, or maybe a different pen with the same fountain, similar fountain pen on the same day. These two are perfectly readable, but the information contained just prior to it,
Understood. The
Ah.
name of the,
name and other particulars, you cannot read it, it becomes so faded. But again, the number on top, that is readable. So if this ink is of a kind which fades over a period of time, the entire thing ought to have faded uniformly. So this is the reason we are asking the question, was it subjected to any kind of treatment?
I don't know, he has provided me that,
I know,
and Shonaram is the grandfather.
you yourself take a look at it.
What is the common one?
So you take a look and satisfy, be satisfied yourself.
Shonaram दिखाई दे रहा है, ये दिखाई दे रहा है। तो ये Shonaram का नाम से है, Shonaram नमस्कार। ये what is this is blood. Shonaram.
But just a minute. Sonaram is the grandfather.
Yes, Lordship.
The guarantor.
I think it's in the name of,
No, if you say Sonaram is the grandfather, the guarantor has to be somebody different, not the father. Father means father of the person who came in.
yes, Lordship.
His guarantor has to be somebody different. His own father can't be a guarantor.
Because
Because
Shonaram,
the father also came along with him.
maybe, Lordship, because his Sumanta's caste certificate is there at page 56. Father's name is written.
Understand?
Shonaram is the grandfather.
So this is a caste certificate issued in the year 1984.
93.
9184 till 9184. 9184, how do you read?
No, no, 83.
Up to date, some December 9184.
This is the school certificate, page 56.
You're referring to page 57.
No, 56. 56 is the father's, petitioner father's caste certificate.
1993.
Yes, his father name is there, so grandfather's name is.
So this shows his existence in the year 1993. Sumanta Namasulva.
Yes.
Sumanta is the father.
Yes,
Petitioner is Gopendra.
Gopendra.
This is issued to Sumanta in 1993.
Yes, Lordship.
So his presence in 1993 can be established by this document.
So, but not prior to 71, no? 77, one voters list is there, but that is also.
That one,
Those-
otherwise you would have accepted it. But if
In-
you, whatever is legible of that name, it does not appear to be SU. It appears more to be SHA or something like that. If you stare at it for a little longer,
It is Shunaram. Shunaram.
It's Sunaram Namaste.
Not so as US is SH.
SHUNA.
U is reverse. The curve is downwards. H, the curve is on the top. The-
SHUNA.
So it cannot be U.
SHUNA.
The letter U, the curve is on the bottom side of the letter. H, the curve is on the top side. Whatever is legible, it is the curve is on the top side, so it can't be U. No?
It's actually in the name of grandfather.
Make sure we shall come back.
Yes, Lordship.
Adjourn on the prayer MSD course, then counsel for the petitioner to examine as to what material is available to show that Sumanta Namasudra, who is claimed to be the father of the petitioner, is himself an Indian citizen.
It is Sunaram Namaste, not in the name of
No, I am going by page 56.
50.
Time being, we are going by page 56. This is Sumanta. List.
May I please, Lordship? Learned additional AG is on left, Lordship.
Sorry.
Learned additional AG is on left. For the timing, Lordship.
He appears in this matter also.
Yes, Lordship. Regarding faulty reference, Lordship.
Sorry.
Regarding faulty reference, Lordship. Regarding reference.
Madam,
Lordship,
in this case,
he was
the
supposed to
tribunal
argue, Lordship.
dispose of the reference, Lordship, as a faulty and return back to
No,
the.
any required to the reference regard to interpretation. Oh, that faulty
Yeah,
reference.
yes, Lordship.
Some
For the
other day.
timing, Lordship. No, for the timing, Lordship.
Item 15 to 17 for hearing.
May it please, Your Lordship.
Yes.
No, here, learned advocate general, he will appear, my lord. In fact, he is
Some
arguing.
other court. Please before in the court.
Oblige, Lordship.
Item 18.
None appeared for a petitioner when the matter was called on 33/2023. On 33/2023, it was ordered to be listed again with an observation that if on subsequent call none appears, adverse order shall follow. Today again, when the matter is called none appears, dismissed for non-prosecution. The Superintendent Police border of which district be informed about the dismissal of the writ petition.
Item 19.
If the petitioner desires, may file the appropriate application for recall of the order of dismissal for non-prosecution.
Item 19.
19. That Padgiri, not Padgiri matter. What is this?
Lordship, this is
Fukan, Mr. Fukan was sitting here some time back. Where is he gone? Whether 302 case also should be tried by a court martial. I think that's a issue.
yes, Lordship.
So who will address?
My lord, this case, Mr. Ranjit Kumar Dev Chaudhary will
He'll
address
come.
it to Yes, Lordship. He
What-
on legs in
What do you want? Timing or some other day?
time being, Lordship.
Item 20.
022 common by lady by say. That is like answering my 302 defect. Say,
Yeah.
past and highly completed law. অকল যে মানুষকে মাৰিব চুৰিব সেইটোতো তেনেকুৱা কোনো কথা নাই কোনে মাৰিব কিয় মাৰিব তেনেকে মাৰিব No, you can already begin it. 23. Yes. No, 20,
May I please your
20.
lordship?
This is item 21.
20
Shah Jahan.
lordship. 20,
20.
Anwara Begum.
21 we said.
Item 20, WPC 169.
Item 21 is also. এবাৰ দিয়াৰ পিছত হেৰি দিলে নেকি ঘূৰাই দিয়াটো নেকি আনবাৰা
May I please your lordship? Petitioner father is Abdul Hussain
page number
and page number lordship 41. Count Suti Park. Anna Bagbor.
Abdul Hussain,
Yes, lordship.
son of Esamuddin,
Yes, lordship.
Gaon Hutirpar,
Yes, lordship. Then next page is 42,
Bagpur.
42, same village,
Hutirpar,
Sutir Park.
19.
Mother's name also is there, lordship, Abdul Hussain.
Earlier it was Abdul Hussain, son of Esamuddin, is the father. Now, who is the mother?
Moimun
Moimun
Nessa,
is the mother. Okay.
and she has adduced evidence, lordship.
Moimun has
Yes,
what
lordship.
did she say?
Her evidence,
What did she state in her evidence?
lordship. Moimun Nessa, page 37, lordship. I know OP Anwara Begum, who is my eldest daughter. The OP was born and brought up at village Satra Kanra.
Was this witness crossed?
No, lordship, I don't find the cross part.
This is oral evidence. No
Yes,
evidence on affidavit.
In an affidavit which.
No, this is oral evidence on
Yes,
essay.
lordship.
Put in. Here, MSD goes to concept for the petition also. The petitioner Anwara Begum had been referred to the Foreigners Tribunal number
Page 4.
4, Borpeta, for rendering an opinion as to whether she is the person who entered the state of Assam on or after 25 May 1971. Resulting in registration of FT case number 501/2016. The tribunal rendered an opinion dated 22/10/2018 declaring the petitioner to be a foreigner, being aggrieved with such petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1971 of village Hutirpar, police station Bagbor, in the present Borpeta district, which contains the name of Abdul Hussain, son of Esamuddin, at serial 184. As well as the voters list of 1989 of village Hutirpathar, which contains the name of Abul Hussain, son of Asamuddin, at serial 600, and that of Moimun Nessa, wife of Abul, at serial 601. It is claimed that Abul Hussain is the father of the petitioner and Moimun Nessa is the mother. Moimun Nessa had rendered evidence before the tribunal as DW 4, wherein she stated that she knows the petitioner Anwara Begum, who is her eldest daughter. who was late and who was later married with Chandumia, son of Mofizuddin of village Tethera. In view of the above, remanded back to the tribunal to examine the voters list of 1971 of village Futirpar and the voters list of 1989 of village Futirpathar, and also the evidence rendered by DW4 Maimun Nessa, whose name appears in the voters list of 1989 of village Futirpathar, and thereafter pass a region order. The respondents in the Home Department may make their own verification and submit report. Region order.
Deeply obliged.
Item 21,
My lord. My lord, yes, my lord. Item 18, my lord, I went to bathroom, my lord.
Mr. Das, we don't appreciate this, just barging in the middle of a proceeding. If you have something, take up with the court master.
My lord, please accept me.
Mr. Das, you are not supposed to disturb somebody else in their proceeding. You cannot just barge into the court and say whatever you want to,
Yes, sir.
when your item is not called. If you have something, take up with the court master. Yes,
No, next thing, my lord.
item 21.
May I please, Your Lordship. This case, Your Lordship, petitioner's grandfather name appear in the voter list of 1966,
66.
page 15, Your Lordship. Page 15. Village Kismat has the.
Page number
16, 16.
16.
66 voter list. Sapatullah Sheikh.
Kismat Hasdoha
Kismat has
Two.
part 3,
66.
66.
Sapatullah Sheikh, he is the father or grandfather?
Grandfather.
Grandfather. Who is the father?
Father is Your Lordship Amjad Ali, Your Lordship.
Page number?
Page 19, Your Lordship.
Page 19. Amjad Ali. Also part 2, 77. Amjad Ali is the father.
Page 17, Your Lordship, can be page 17, along with the grandfather. Page 18, 18.
Page
18,
18. Okay, both are together.
Lordship, together, Your Lordship.
This is of which year?
It is the 1993.
93. Okay, 93 same it is. Now, which document will show who is the petitioner? Shahjahan Ali. Which
Shahjahan Ali,
document? Shahjahan is the son of Amjad.
Lordship. In this case, Your Lordship, voter list, not along with father, his first name is 2015. Your
Page,
Lordship, page 15 to
15?
27.
sorry, page 15 or
No, Your
27?
Lordship, 27 page.
27.
Voter list of Your Lordship. Is the first time appeared his name.
What is this? Page 27?
27, Your Lordship, type group is
It's a voters list.
It is correction, Your Lordship, Sankhodhani voter list, Your Lordship. Kismat Hoda part 3. Kindly notice, Your Lordship,
Where is the original?
page 28, 28. Petitioner's name.
Where is the name of the
Right,
village?
right hand side, middle portion.
No,
Shahjahan
no,
Ali.
where is the name of the village? Kismat Hasdo, take your Khando. Shahjahan Ali.
Your Lordship, middle portion, Your Lordship. Kismat has the part.
Mr. Sharma, send it back. Heard Mr. S. Islam, counsel for the petitioner, also heard Mr. The petitioner Shahjahan Ali had been referred to the Foreigners Tribunal number 2, Kamrup Metro at Guwahati, for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 110/2015. The tribunal rendered an opinion dated 3/11/2018 declaring the petitioner to be a foreigner. Being aggrieved, the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Kispat Hasdoha part 3, Moza Dhubri in the present Dhubri district, which contains the name of Sapatullah Sheikh, son of Pataru at serial 163. As well as the voters list of 1993 of village Kismat Hasdoha Part 3, which contains the name of Sapatullah Sheikh, son of Pataru at serial 395, and Amjad Ali, son of Sapatullah Sheikh at serial 396. Sapatullah Sheikh is the grandfather and Amjad Ali is the father of the petitioner. Reliance is also placed in a vote in 1997 of village Kismat Hasda Party containing the name of Amjad Ali, son of Sapatullah at serial 675. And Sahira Bibi, wife of Amjad at serial 676. And it is claimed that Sahira Bibi is the mother of the petitioner. Thereafter, Reliance is placed. The voters list of which year? Page 28. Of the list of 2015 of village Kismat Hasdor Part 3, which contains the name of Shahjahan Ali, son of Azmat Ali, Amjad Ali at serial 701.
House number 262, same page.
What happened to the other family members of Amjad Ali? No one is there.
In this case, it is correction voter list. First time his name paper 2015. In the 2015 and voter list, I have also annexed in page.
Accordingly, it is claimed that the burden under Section 9 had been discharged in as much as the voters list of 2015 of village Hasdoa Part 3 shows that Shahjahan Ali is the son of Azmal Ali, whereas the son of Amjad Ali. Amjad Ali. Whereas the voters list of 1993 of the same village shows the name of Amjad Ali along with Sapatullah Sheikh, where the name of Sapatullah Sheikh appears in the voters list of 1966 of Kismat of village Kismat Hasdoa Part 3. In view of the remanded back to examine the voters list of 1966 and 1993 and 2015 of village Hasdoa Part 3 and pass a revision of them. Respondents may make their verification and submit a report. The respondent also verify whether the Shahjahan Ali of the 2015 voters list at serial 701 and the writ petitioner Shahjahan Ali are one and the same person.
Item 22.
Yes, which page?
My bills. Father name is Abul Hussein Melot and grandfather name is Bahez Ali Melot.
Page number?
Page 23 Melot, 66 voter list.
2366.
Page
Tokar
23.
Chor.
Tukar Sorman. Bahez Akram Melot.
Bahez Ali is the father, grandfather.
Grandfather.
Right.
And father name appearing in voter list of 1970 Melot.
Page number?
Page 25.
25.
Serial number 47.
And what's the name of the father? Ibrahim.
Abul Hussein.
Abul.
Yes, Abul Hussein.
Father. Okay. So now which document will show that Sultan Mahmud is the son of Abul?
One parcel deed Melot, page 46.
Page 46. Sultan Mahmud. Peter.
Sultan Mahmud.
Land is purchased in which place? Tukrachor?
Tukar, sir.
Tukrachor, same place.
It's same.
Heard Mr. A.M. Ahmed, Land Council for the petitioner, also. The petitioner, Sultan Mahmud, had been referred to the Foreigners Tribunal number.
The tribunal second of Boingao second of
Foreigners Tribunal number 2, Bongaigaon at Obhayapuri, for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number BNGN/FT/2060/07. The tribunal passed an order dated 29/7/2019 declaring the petitioner to be a foreigner, being agreed this petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1966 of village Topkarchor, which contains the name of Bahiz Ali Akhan, son of Asaruddin, at serial 36, as well as voters list of 1970 of village Topkarchor, which contains the name of Bahiz Akhan, son of Asaruddin, at serial 42, and that of Abul Hussein, son of Bahiz Ali, at serial 47, where both are residing in the same house number 12. It is claimed that Bahiz Akhan is the grandfather of the petitioner and Abul Hussein is the father. To substantiate the same, reliance is placed upon a sale deed. It's a registered sale deed.
registered.
Where is the registration number?
And then his next page, my lord. And next page, my lord.
Registration number?
Registration number, my lord.
There is no registration number.
Here is. There's one number in. It's not visible, my lord.
On a sale deed of a plot of land at village to Kachar, wherein the purchaser is shown to be Sultan Mahmud, son of Abul Hussein of village to Kachar. By placing reliance on the sale deed, petitioner also relies upon Chitha of a plot of surveyed village of a plot of land at village to Kachar, wherein the information, which contains the information that by an order of the circle officer dated 11/12/2017, land had been mutated in favor of Sultan Mahmud in place of Abul Hussein, which again would be an indication that the land had been mutated in favor of Sultan Mahmud, son of Abul Hussein of village to Kachar. Remanded back to examine the voters list of 1966 and 1970 of village to Kachar, which contains the name, where 1970 voters list contains the name of Bahiz Akhan, the acclaimed grandfather, and Abul Hussein, the acclaimed father of the petitioner, as well as the referred sale deed and a copy of the Chitha of surveyed villages, which also contains the information that Sultan Mahmud is the son of Abul Hussein of village to Kachar. And they have passed a respondents make the verification, submit report. Pass the revision order.
Item 23.
Lordship, at the outset, I gave your lordship indulgence to please certain actual background of this matter. And also maybe pleased to hear me on this.
What is this IA?
IA, it is actually not IA. It was at the outset. The case was actually instituted.
No, why was this IFI praying for so as to please to release the applicant, Tezpur jail? He is still in detention.
Released.
Released. IA to the IA 898/20. This interlocutory application had been filed by Nurul Amin, the writ petitioner in WPC. No, by Nurul Amin, son of Abul Hussein, where Abul Hussein is the writ petitioner in WA 49/2020, praying that who should be released? Abul Hussein. praying that the applicant be released from the detention camp at Tejpur. It is stated that in the meantime, the applicant had been released from detention and therefore no further order is required. In the I closed. Yes, now read appeal.
That's it.
Read appeal.
That's it. Read appeal. It's a come before your revision bench on read appeal. In the earlier, there are the single bench who had.
It has
And
to be.
there this division bench, we invoked this.
Mr. Huda, it has to be. Read
Yes.
appeal is always against the order of the single bench.
Yes, at that
So
time.
now what is your case now?
Case because here it is a matter. A founding son, actually a boy, particular 5 years or 4 years boy, was found in Dharmtul railway station. And after that, he was taken by somebody. He was brought up.
A 5-year-old boy was found at
at
Dharamtur
Dharmtul
railway station.
He's a founding person, founding son, according to
Sorry,
original actually law of origin and of actually to have the citizenship and all that. So when he
I
was
have not
found,
understood what you were saying. We only understood one 5-year-old boy was found at Dharamtur railway
Dharmtul
station.
station,
After that, what happened?
after that he was taken by some other person in the village.
Somebody,
Somebody had taken him
some unknown person had taken him.
and yes.
Huh.
And thereby he was actually brought up there. And according to Muslim law, it is that one should be actually this of adopted son and all that. He was actually taken up, given shelter. And accordingly, he was taken to some other family, Hindu family, who actually kept him for 5
So
or 10 years.
one family took him for some time, then another family took him
For example,
thereafter.
on different religious persons. So in both religious group, actually maintain him in 2 ways. One actually first at the outset in a Muslim.
So the
house.
Muslim family maintained him in a Muslim,
Muslim, yes, subsequently he was taken by
following the
Hindu
Muslim tradition, the Hindu family maintained
was there
according
for
to
some
Hindu
time.
tradition. Very well. After that,
After
what
that,
happened?
he again shifted to this Muslim family.
Again, he came
Why?
back to the Muslim family.
He
Very
was actually that found that person, his brother's daughter, he married in due course of time. And
Achha, after coming back to the Muslim family, he got married.
he got married in that family.
So now what is the issue here?
Now, Abul Hussein, whose name is here.
Let us read the judgment of the court. We'll understand
Yes.
the issue. Page 56.
Page 56. Lots of this matter.
Page 56. The writ petition is against the judgment of this. For mistiming it. Who is that name of that boy who was found in the railway station? Abul Hussein.
Abul Hussein.
Abul Hussein
Yes,
was
sir.
found in the railway
Yes,
station. Okay. In which year the boy was found in Dharamtur railway station?
Actually, nowhere it is, the date is mentioned, so what I have actually done through.
No,
Likely 56.
no,
or
no.
51, 51, that's it.
Just a minute, Mr. Huda.
That's it.
If the person was an abandoned person found in a railway station,
That's it.
one Tajuddin had adopted
I
him.
got that
Tajuddin kept the boy for some time.
sometime.
Then it went to Dhoniram Hoike.
I guess it.
Dhoniram Hoike again maintain the boy in his own manner. Then again, the boy came back to Tajuddin. On which date, for the first time, Tajuddin had found him?
Well, actually, I have.
Otherwise, how can you prove your case? You cannot prove your case to Dhoniram, nor you can prove your case to Tajuddin. Because admittedly, this was an abandoned boy. So, citizenship by adoption is not there under the Indian law.
Not there, never.
Suppose an Indian citizen adopts this boy.
Yes.
I think by adoption, citizenship is it available? Citizenship by adoption?
I don't.
Mr. RKD Chaudhary,
Don't.
any idea? Citizenship by adoption? Because we have not come across any such provision in the Citizenship Act. Suppose a person is a foreigner. Let us take a more easier case. An Indian citizen adopts him.
I have to see.
What will be his citizenship? Because this is a peculiar situation. Mr. Huda says this boy was found. Now he is a man, of course, the petitioner before the court. Found abandoned in Dharampur railway station. One Tajuddin adopted him, took him. Continued for some time. Then the boy was adopted by one Dhoniram Saikia. Dhoniram Saikia even brought up the boy in his own tradition. Thereafter, the boy again went back to Tajuddin. Now he is married and all. This person is being referred to the tribunal. So what will be the boy prove? So one question I am asking Mr. Huda, when was the first time Tajuddin found this boy?
That would be.
If that was before 25/3/1971, you don't have to prove anything else.
Yes.
So this man cannot be proceeded any further
That's it.
from wherever he may have come from.
Yes.
But if this adoption was after 25/3/1971, the question will arise, he may have come from Bangladesh. If he had come from Bangladesh, he will be a person who came from the specified territory after the cutoff date. So he'll be a foreigner. But he has been adopted by Tajuddin, whether by following the law or this will look into it later on. If Tajuddin has adopted him, what will be his status? Provided Tajuddin himself is an Indian citizen.
No, actually, Tajuddin was never asked that to submit anything about his.
No, he may not have asked, but we are asking him now to submit. Suppose first call we have to take whether Tajuddin himself is an Indian citizen.
Indian citizen.
If Tajuddin is an Indian citizen, by virtue of adopting this boy, what will be the citizenship status of that boy? This is a complicated law. You have to argue on those things.
Yes. And the appellate form I have appeared in this case. The idea I don't think before.
No, that doesn't matter. You argue on merit of the matter. We'll hear you.
So this is a become a such critical. Actually, I have to answer.
You cannot throw your problems at us.
No,
and
no.
now you say you have to make a legal submission.
But that is why
One time you will grant you time. You think over the matter.
Lordship, I will be.
Firstly, prove on facts on which date Tajuddin had adopted. If that date is prior to that 1971 cutoff date, then you don't have to bring any further document. That is good enough.
Lordship.
If it is after 71, next question will come is whether Tajuddin himself is a citizen or he is not a citizen. Because this boy will be claiming from Tajuddin. Then the second question will come upon Tajuddin, if he is an Indian citizen and he had adopted this person, what will be the citizenship status of that adopted boy?
That's why actually I am giving words. I have satisfied your Lordship.
Please confine to these issues.
It is actually.
You may like to say too many things, but that won't be of much relevance for us.
Yeah, when I yesterday I studied this paper, I actually asked a question, but engineers told him that they pay before your Lordship for a few days so that I can study well. What is it?
And Mr. Sorry, any provision citizen status of a adopted person?
I have not come across.
Frankly
I'll check-
speaking, I have not come across. That's why I'm asking.
Check up once again. If there is anything, worship.
Don't take such a complicated case. Suppose today one boy comes from another country. Say everything is legitimized. He is adopted by an Indian citizen. What will be his citizenship?
I'll try to find out.
Mm.
I'll try to find out. If actually prior to 1970.
Okay, that's why I said first
Let's take a situation.
example, a more simpler case.
Let's-
Forget about the 71 in Bangladesh and all.
Achha.
Suppose a boy from a foreign country is adopted by an Indian citizen. From the day of his adoption, what will be his citizenship? He continues to be citizenship of the earlier country, or he'll, by some law, some provision, he'll be a citizen of India.
I will leave notes.
And also see what is the reverse law. When an Indian boy is adopted by a foreigner somewhere, say some European, lot of adoptions take place.
Exactly.
As per their law, what happens to the citizenship of that boy? He becomes a citizen. Suppose one Swedish national comes to India, adopts a Indian child, and goes back. Takes the boy along with him. Under the Swedish law, what will be his citizenship? He gets a Swedish citizenship by virtue of adoption, or he retains the Indian citizenship? Please explore. It's a much larger subject than.
A short time.
Heard Mr. S. Woodall and counsel for the appellant. The factual background narrative is that the petitioner, the appellant Abul Hussein, was found abandoned at Dharamtur railway station. And thereafter, Tajuddin had adopted him and kept him for some time and made Abdul Hussein to grow up by following the tradition and culture of Tajuddin.
Yes.
Thereafter, another person, Dhoniram Saikia, had adopted Abul Hussein, kept with him for a certain period, and during that time, Abul Hussein was brought up by following the tradition and culture followed by Dhoniram Saikia. Subsequently, Abul Hussein was reverted back to Tajuddin and later on also got married. In the meantime, Abul Hussein had been referred to the Foreigners Tribunal for determination of his citizenship.
Yes.
In the circumstance, Mr. S. Woodall and counsel appellant seeks for adjournment to examine the citizenship status of Abdul Hussein in the aforesaid facts and circumstance.
In the meantime, his wife actually expired. They have informed me yesterday. His wife, then he married, actually, she is also FTR case. She is also one of the.
No, with that, wife
We'll-
will
we'll-
take care later on.
we'll make
Doesn't
it.
matter.
Gotcha. Awesome.
You need not appear, Mr. Chaudhary. If you have any information, we can,
Since it has come,
I can
it is interesting. I will try.
tell
to-
my Mr. G. Sharma or
Yes, yes.
whoever appears.
I'll
Or
try
if
to
you
find
want,
out,
you are
sir.
always welcome.
I will come. I'll try to find it. Thank you. Thank you.
After 2 weeks, Mr. Huda? After 2 weeks?
After 2 weeks.
Yeah, please, please.
Before,
Yes, Mr. A. Ali. Bilal Hussain. Who is the father of Bilal Hussain?
Prohibition is the father.
Hmm.
The lordship will find the name of Prohibition at page number 15. 49.
Page number
49. 49.
49. This is South Salmara, village Barcolia, Sarso.
Says. Is
We-
the father?
Who is the father?
My lord, Rohim sir is the father and the petitioner before your lordship, page number 53 may kindly be perused. Page number 53 is the birth certificate.
Mr. Counsel, please give the reply to the question asking who is the father and which voters list his name appears.
My lord, Rohim sir is the father.
Haris Ali.
Rohim sir, my lord.
Rahim. Rahim Chan is the father. Okay, fine. So this is the voters list of 1997.
97. And the name of the petitioner, your lordship will find at page number 53.
Rahim Chan
Rahim Chan is
name
the
appears in
petitioner's-
1997.
My lord.
Does his name appear in any voters list prior to 71?
My lord, father's name is not there.
No. Grandfather's name?
Grandfather's name.
Where is it?
Your lordship will find at page number 40,
Sorry,
44, my lord.
44.
Even great grandparents' name is also there, my lord.
Page
Page number 60,
44.
Hanif Ali Sheikh is the grandfather.
Who is the grandfather?
Hanif Ali Sheikh.
Hanif Ali Sheikh is the grandfather.
Yes.
This is Gao Ambari Union.
Indian, my lord. This is the name of the, my lord, name of the village of the voting center.
No, what is the name of the village?
That is, my lord, Borkule Serso, my lord.
No. Come to page 44. That voters list is of the year 1960.
60, my lord.
Say, I think 1960.
Yes, my lord.
It is of village Ambari Union.
My lord. Ambari Union, my lord. Yes, my lord. Name of the village.
Are you prepared? Are you prepared with the matter?
Yes, my lord.
Are you? If you are prepared, please submit. Please make your submissions.
Yes, my lord. So, name of the grandfather, my lord, for the first time appeared in the year 1960, my lord. That your lordship will find at page number 44. And subsequently, my lord, 45, my lord, that is the voter list of 1966, my lord. Dear 34, my lord, Hanif Ali Mondal, here in this.
Yes, please continue.
My lord. Here, my lord, Hanif Ali Mondal is there, my lord, at page number 46. The name of the village is, my lord, Borkulia Sherso, my lord. Then comes, my lord, the voter list of 1970. The lordship will find at page number 47, my lord. This is also from Borkulia Sherso, my lord. Then
Yes, Mr. Sharma.
Mr. Sharma, what do you say?
Lordship. If your lordship may only have a look at this 53 lordship birth certificate, this is of different village lordship. And he is also present resident of Ambari Piapara lordship. And voter list.
No, Rahim Chan is the father. Now, which document will show that Belal Hussain is the son of Rahim Chan?
this is 53, my lord.
53.
My lord. The petitioner was born at village Ambari Bhuepara.
Village of grandfather is also different lordship, Ambari Union.
Your name, please? Your name?
A Ali.
AI?
A Ali.
A Ali, Mr. Ali.
Yeah.
The materials are not consistent.
Yes, lordship.
Firstly, you come to page 44.
Yeah.
Hmm. This is of 1960
Yeah.
and village is Ambari Union,
Yeah.
Daghor Fakirganj,
Yes, madam.
Hanif Ali, he is the grandfather. Yes. Then 66 village Borkolia Sarso.
Yeah.
Borkolia Sarso. Earlier village was Ambari
Ambari
Union.
Union.
Here you get Hanif Mondal and Falani Nessa.
Yes, madam.
Then you have 1970
Yeah.
Borkolia Sarso. After that, you have 1997 Borkolia Sarso, Rahim Chan. Rahim Chan is the father.
Father.
Yes, Mr. Sharma, you also look along with it. And Falani Bewa, wife of Hanif Ali, is also there. Have you noticed?
Yes, yes.
1970, along with Hanif Ali, Falani Nasa is there, wife of Hanif. At page 49, Falani Bewa, Hanif must have died in the meantime. And Rahim Chan. Rahim Chan is the father.
Yes.
Now, if you look at the birth certificate, Bilal Hussain,
Yes.
name of father is Rahim Chan,
Yes, lord.
village Ambari Bhuyapara.
Yeah.
That 1960 is something like Ambari name.
Ambari Union.
Ambari Union.
But here again you see post office Borkodias also. Must be more or less the same place. And police station is Fakirganj. In the 1960 voters list also, you'll find the name Fakirganj.
Post office was Fakirganj.
So you examine whether it
Yes,
is same or not. I think some consistency is there. Heard Mr. A. Ali, learned counsel for the page. The petitioner Bilal Hussain had been referred to the
Yes,
Foreigners Tribunal number 3 Kamrup Metro at Guwahati for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 258/2017. The tribunal rendered an opinion dated 34/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted in the writ proceeding. The petitioner relies upon the voters list of 1960 of village
Ambari Union.
Ambari Union, post office Fakirganj in South Salmara, which contains a name of
The grandfather.
Hanif Al. Please don't go on uttering. You can take your seat.
Yeah.
Hanif Ali Sheikh, son of Hafiz Ali, not Hafiz, the son of Ibrahim Ali, at serial 60. And it is claimed that Hanif Ali Sheikh is the grandfather of the petitioner. In the voters list of 1966 of village Borkolia Sarso, the name of Hanif Ali Mondal, son of Ibrahim, appears at serial 34 and that of Falani Nesa, wife of Hanif, at 35. And both are shown to be residing in the same house number 16. In the voters list of 1970 of village Borkolia Sarso, name of Hanif Ali Mondal, son of Ibrahim, appears at serial 36 and that of Halani Nessa, wife of Hanif at 37. And both are residing in house number 14. In the voters list of 1997 of village Borkolia Sarso, the name of Falani Bewa, wife of Hanif Ali, appears at serial 102 and that of Rahim Chan, son of Hanif, at serial 103. And it is claimed that where both are residing in the house number 37. And it is claimed that Rahim Chan is the father of the petitioner. To substantiate the same, a birth certificate issued by the government of Assam in the Department of Health Services is relied upon, which contains the information that Bilal Hussain is the mother of Bilal Hussain is Halima Khatun and his father is Rahim Chand of village Ambari Bhuyapara, post office Borkolia Sarso, police station Fakirganj in the erstwhile Dhuri district. Relying upon the information contained in the birth certificate, a claim is made that the petitioner had discharged the burden that he is the son of Rahim Chan of village Ambari Bhuyapara, post office Borkolia Sarso, police station Fakirganj. The citizenship of Rahim Khan can be established from the voters list of 1997, where his name is shown along with Falani Bewa, his mother, where the name of Falani Nisa appears along with Hanif Ali Mondal in the voters list of 1970 and 1966 of village Borkolia Sarso. Full stop. In view of we also noticed that we have already noticed that in the voters list, of 1960 referred above is of village Ambari Union, post office Fakirganj, whereas the voters list of 1966 and 70 are of village Borkolia Sarso and Sarso. The information contained in the birth certificate is that Rahim Chan is of village Ambari Bhuyapara, which again has similarity with Ambari Union of the 1960 voters list. Post office is Borkolia Sarso, which is consistent with the village of the voters list of 1966 and 1970. And police station is Fakirganj, which again is consistent with the post office referred in the voters list of 1960. We have ever remanded back to enable the tribunal to examine the voters list of 1960 of village Ambari Bhuya Union, 1966 and 70 of Borkolia, 66, 70 and 97 of Borkolia Sarso, as well as the birth certificate issued by the Health Department of Guwahati, Assam, and pass a region order. Respondent may make their own inquiry, submit report.
1970 to 1997, there was no.
The petitioner to produce all the intervening and complete voters list from the year 1966 to 1997 for examination of the tribunal. This one.
Item 14. I think we take it up next week, man. The reference.
14 to Dheri as paid for list on sales.
By President Tribunal at Syria, but for non-availability of the region opinion matter, that was set aside by the High Court and remanded that. Then again, proceeding started there, and second time here.
Petitioner is Motibur Rahman.
Yes.
Who is the father of Motibur Rahman?
Habibullah Mali.
Which page?
Page 16, Jamabandi Malot, 16 and 17.
Page 16.
Father's name and Habibullah's name and his father's name is there in the
Page
Jamabandi.
16. Habibullah Sheikh,
Yes. Habibullah
son of Tasu Sheikh.
His name is at number 1 and Batipur Rahman's name is serial number 5.
Motibur Rahman, son of Habibullah, at serial number 5.
Yes, please.
So these are incorporated by which order of the circle officer?
Total is not a clear, okay?
Nurul Amin Modiam Nessa Habibullah. Their names are mutated by an order of 3/1/1998.
Yes, my lord.
So how do they prove that they are citizens? Suppose his father is Habibullah Sheikh and this land is in which place? Jamuguri.
Yes, my lord.
Jamuguri. So how will you prove that Habibullah Sheikh is a citizen?
We will, he has got, my lord, total list of 65. and
Page number?
also-
Page number?
Page number, my lord, here. Total list of.
It's number
mm,
21.
Page number 20, my lord, 20 and 22.
20. Habibullah Mir.
Yes, my lord.
But this is Habibullah Mir
Yes,
and this is
Habibullah Sheikh.
Habibullah Sheikh. Are they the same person?
yes, my lord. And the same village, Damoguri, my lord.
No. In the same village, there may be two persons. One is Mir and one is Sheikh.
No, which? Other,
In the same village, Jamuguri,
yes, my lord.
there may exist one Habibullah Mir, another Habibullah Sheikh. How do you know that they are the same person?
Which one is the second, my lord? In total list, it is me, my lord.
That's what Mr. Das. Voters list contains name of Habibullah Mir.
Yes, sir.
Jamabandi contains the name of Habibullah Sheikh. Please read carefully.
No, there-
What's a Mir? Oh, it's a Mir. Mir, Mir.
Which has been related, my lord. Should be
Yeah,
serial
okay.
number 1 may be serial number.
Habibullah.
Habibullah main name is there.
Yes, Mr. Sharma. What do you say? Go back. Okay, yeah. Heard Mr. BC asked the counsel for the petitioner also heard. Petitioner Motiur Rahman had been referred to the foreigners tribunal number
4, my lord, is wrong.
tribunal number 4, Nogao
At jury.
at Juria to render an opinion as to whether Muhammad Motibur Rahman is a person who entered the state of Assam from the specified territory on or after 25/3/1971, resulting in registration of FT case number 128/2016. The tribunal, by the opinion dated 17/10/2019, declared the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ petition, the petitioner relies upon the voters list of 1965 of village Jamuguri, police station Rupohi Hat in the Nagaon district, which contains the name of Habibullah Mir, son of Asu Mir, at serial 7, and that of Asiran Nessa, wife of Habibullah, at serial 8. It is claimed that Habibullah Mir is the father of the petitioner and Asiran Nessa is the mother. To substantiate that Habibullah Mir is the father, reliance is placed on a Jamabandi in respect of a plot of land at village Jamuguri, which contains an order of the circle officer dated 3/1/1998, by which land in respect of Patta number 568 had been mutated, amongst others, in the name of Motibur Rahman, son of Habibullah Mir, in place of Habibullah Mir. And in the column for names of the Patadar, the name of Habibullah Mir, son of Tasu Mir, had been struck off, And in his place, the name of, comma, Motiur Rahman, son of Habibullah Mir, comma, amongst others, comma, had been included. As a petitioner, name of the petitioner had been mutated in place of Habibullah Mir, and Habibullah Mir's and the name of Habibullah Mir appears in the voters list of 1966 of village Jamuna Mukh. The land also Jamuna Mukh, what to remind you. The petitioner claims that the burden under Section 9 had been discharged. If you remanded back to the tribunal to examine the voters list of 1966 and 1970 of village Jamuguri, as well as the Jamabati of the plot of land of village Jamuguri, and thereafter pass a reasoned order. Respondents make their own verification, submit report.
Item 26.
It's Mr. Dick,
Hey, please, your lordship.
review.
My lord, this is a review petition, my lord.
Hmm?
A review petition, my lord.
Review, huh?
My lord.
These are you. Review against which order?
Against my lord order. Page 49 annexure C, my lord.
Page 49, annexure C.
C. Order dated 11/6.
Why this order is requires a review?
My lord,
Why the order requires a review?
my lord. When the petitioner submitted the documents, my lord, one document, that is voter list of 1993. He could not collect the voter list and could not produce before the learned tribunal, my lord. Subsequently, a petitioner was declared foreigner due to non-proof of the linkage with his father, my lord. And subsequently, my lord, this
So now you want to produce the 1993 voters list.
my lord,
That's,
and that was produced before.
so that is
earlier,
the reason for the review.
my lord, that he could not.
Yes,
collect.
Mr. Sharma, what do you say? Recall maybe, review order, order. Again, order now. What do you do? We recall the order of 11/6. Mr. Sharma?
Lord. Yes, Lordship, I have no objection regarding that.
Or
but
you want
Lord-
to file
but
affidavit?
Lordship, no, Lordship, I have nothing to say regarding that, but Lordship, I think there was a delay of filing this review petition, Lordship. So
Petition is not there.
I think.
Delay of how
it is
many
not
days?
there.
Oh, one
Perhaps 9
IA,
months
one
delay.
IA is there.
My lord, petitioner went to Supreme Court also, my
No,
lord.
no, one IA is there for
I think-
extension of time. Extension of time for appearing before the SP border.
Yes,
Okay,
9 months delay, Lordship.
9 months.
A
delay.
review petition.
It's stated by Mr. G. Sharma, Land Counsel for the responding Home Department, that there is a delay of approximately 9 months in filing the review petition. Mr. PC Day, Land Counsel, seeks for an adjournment to file appropriate application for condoning the delay. List after filing of the application for condoning the delay.
Must-
27.
So, Hasmat Ali,
Yes.
who is the father of
Father's name is Kitab Ali.
Kitab?
Yes.
Where is his name?
Page 16, 16.
16.
Ines Lalipatha.
65, Kitab, Gaon Ladi Pathar. Logo. Change. So which document will show Kitabali is the father?
Yes, my lord. And my lord, in the voter list 1977,
Page number
page 20, my lord, mother name is there. My lord.
is 20, mother's name. Ukiljan.
Yes.
Ukiljan is the
Yes,
mother.
Mother.
Where is the name of Kitab
Yes.
and Ukiljan
Yes,
together?
my lord. One voter list, my lord, in 1989, my lord. Here, my lord.
Kitab and Ukiljan together.
Here, my lord, Jamshed Ali, elder brother, and the mother name is also appear. And
No, that
petition-
is okay. But where is the name of the father and mother together?
Yes,
You have shown father individually in 1965.
yes.
You have shown mother individually in 19. What is this? 1977.
Yes.
But do you have any voters list where both the names appear together?
My lord, in 1977.
Both the names are there. You bring that on record.
And one land Jamabundi, my lord. In addition, my lord.
Where is Ukil and Kitab together?
Serial number, my lord,
Which serial number?
in the next page, my lord. This voter is 1977.
There's a difference between next page and serial number.
In 1977.
There are about hundreds of
I am-
serial
I
number.
am
Which
not
one do you have to
marking
look
my lord.
into?
And next page, my lord, I'm marking.
Yeah, mark it. Okay. No, we want to see the name of Ukiljan and Kitab together.
Yes, my lord, serially, my lord. House number,
Jamshed Ali, Pita Kitab, Ukiljan.
top, my lord, Kitabali.
Okay, Kitab Ali, son of Imam.
Lali Pathar.
Lali Pascal.
This is of which year? 1977.
77.
Who is the petitioner? Jamshed.
And no, my lord. Asmot Ali. Jamshed Ali, my lord, elder brother, my lord.
And who is the petitioner?
Asmot Ali.
Hasmot Ali.
Yes.
Where is the name of Jamshed and Hasmot together?
My lord, 1989.
89.
One voter list and a certified copy and one is complete voter list.
Okay. Third, Mr.
I
What?
think there is a 60.
And one Jamabundi.
It's same village, continuously, it's consistency is there.
Yes, Lordship, but he is a present petitioner is of Laogao, Lordship. I think there is a 16.
No, we'll put a thing.
Yes, Lordship.
We'll examine whether Hasmot of Lalgaon and Hasmot of Lalipothar are the same
Yes,
person.
yes,
yes.
And you also make your own inquiry. Your name?
A.M. Ahmed, my
Huh?
lord. A.M. Ahmed,
A.M.
at the rate, my lord, A. Mutin, my lord. Everybody knows me, my lord, A. Mutin.
That's a difficulty. You are also an LIS, like your client. Yeah, Mohammed. The petitioner Hasmat Ali had been referred to the foreigners tribunal number.
Tribunal number, furnace tool first, no,
Page number
is 45.
45. And refer to the foreigners tribunal number 1, Nagaon, for rendering an opinion as to whether he is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 528/09. The tribunal rendered its opinion dated 30/12/2020, declaring the petitioner to be a foreigner. Being aggrieved, this petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Lalipathar, police station Dhing in the Nagaon district, which contains the name of Kitab Ali, son of Iman, at serial 82. Which information is also contained in the voters list of 1970 of village Lalipathar. Petitioner also relies upon the voters list of 1977 of village Lalipathar, which contains the name of Ukil Jan, wife of Kitab Ali, at serial 670. It is stated that Kitab Ali is the father of the petitioner and Ukil Jan is the mother. This one is of which year? This one is of which year?
77.
77. The complete voters list of 1977 of village Lalipathar shows that. It shows the contains the name of Kitab, contains the name of Iman, son of Alim, at serial 653, comma, Kitab Ali, son of Iman, at serial 655, Ukil Jan, wife of Kitab Ali, at serial 670, and Jamshed Ali, son of Kitab, at serial 677. It is stated that Iman is the grandfather, comma, Kitab Ali is the father, Ukil Jan is the mother, and Jamshed Ali is the elder brother of the petitioner Hasmat Ali. To substantiate that Jamshed Ali is the elder brother, reliance is also placed on the voters list of 1918, 89 of village Lalipathar, which contains the name of Jamshed Ali, son of Kitab Ali, at serial 701, and Hasmat Ali, son of Kitab Ali, at serial 708, and both are shown to be residing in the same house number 160 bracket 4. Reliance is also placed on a Jamabandi in respect of a plot of land at village Lalipathar, in which contains the information that as per the order of the, which order? Circle officer? It shows that as per the order of the circle officer dated 21/10/2016, in mutation case number 1337/2016-17/FMUT, comma, the name of, comma, amongst others, comma, Hasmat Ali, son of come to that serial number 10 in the third page of this Jawabandi. You don't have.
Sorry,
order circle officer or order date to change corridor. Order of the circle officer dated 31/3/89, land 31,389. In mutation case to 9. Mutation case number 9 hai yate. Land had been mutated, amongst others, in the name of Hasmat Ali, son of Kitab Ali, in place of Kitab Ali. By referring to the order of mutation, it is claimed that it is stated that petitioner could establish that he is the son of Kitab Ali of village Lali Pathar. In the column for Patadars also, in place of the name of Kitab Ali, name of Hasmat Ali along with others have also been included. You were remanded back to examine Gotegeta, voters list of 1965, 1970, 1977, 1989 of village Lalipathar, as well as the Jamabadi in respect of the plot of land at village Lalipathar. Thereafter, pass a reasoned order, respondents to make their verification, and more particularly, whether Hasmat Ali, son of Kitab Ali of Lalipathar, village Lalipathar, and writ petitioner Hasmat Ali, of which village, Mr. Sharma? Of Laogaon are one and the same person. The tribunal to also examine and pass a reasoned order as to whether Hasmat Ali of Lalgaon and Hasmat Ali of Lalipathar are one and the same person, and they are to appear on so and so.
Item 28 to 46.
Wait, please. In this matter, my lord, item number 35. Fresh IA was filed. My lord. We need some time to file a reply to the item number 35.
35.
Yes, my lord. These are all connected matters, my lord.
No, first you have to decide the writ appeal. You argue on the writ appeal. Later on, we'll see what is to be done.
The writ appeal, Mr. Kane Chaudhary is appearing in this.
Sorry,
Mr. Kane Chaudhary is
where is he?
When this matter lordship were informed that an adjournment will be sought, your lordship.
Sorry.
We are informed that an adjournment will be sought, lordship, by.
Court don't go by what your information you have. We go by the list before us. You want to start or you don't want to start? Don't put the blame on somebody else.
I may be permitted to call me senior, lordship.
Sorry.
I may be permitted to call me senior, lordship.
Call. Your private information cannot be a reason for the court to take note of.
Apologize.
In seeking the retail your lordship.
Lordship is taking the retail lordship. Item. Those matters lordship has heard quite the time lordship.
So what do you mean to say?
No, I'm just indicating lordship, these are the same.
No, we
matter.
don't want indications. We want direct submissions.
Yes, lordship.
If you want, you start. If you don't want, you don't. Up to you.
Lordship and seniors, this is just coming lordship, we are in a different impression here lordship.
Sorry.
We
We don't go, can't
Yes,
go by
lordship,
impressions.
I appreciate lordship, I appreciate lordship's view
If
lordship.
you go by impressions, we don't know where to get the impressions from.
No, that's true lordship.
It's up to you. Yes, Mr. Chaudhary, if you are interested, you can start.
Yes, ma'am. No, my lord, actually, the other side. made
No,
a-
I've been told, but we can't go by private informations.
My lord,
And if you see the manner in which it's thought to be deferred, it's a little disturbing also.
this makes sense.
So it's up to you. If you want to start, you start, because it is your appeal. This is the first item.
Yes,
We have to hear you.
Yeah.
And
My lord, I may briefly indicate the background why I have to file the appeal, my lord. My lord, as far as this,
Just one small clarification. Which one we start hearing? Writ appeal? Because there are a number of writ petitions,
once your lordship decides the writ appeal,
then the others
then-
will
no, my
follow.
lord, by deciding the writ appeal, lordship will deal with one aspect,
Huh.
and by taking the writ petition, lordship will decide the both the aspects,
Consequential
Ah.
aspect.
consequences. It is something like this, my lord, as far as state.
No,
of-
suppose I allow the writ appeal.
Yes,
What will happen?
then the moment your lordship allows the writ appeal,
Hmm.
then until coming into force of an office memorandum dated 18/1/23, my lord.
No, I'm not.
No, no, I'm saying because,
So much of details I'll have to go into.
if your
No,
lordship,
suppose I
if
dismiss,
your lordship
then
allows
what will happen with the other writ petitions?
the other writ petitions, lordship will have to decide with effect from another date, that is 18/1/23.
Money individually, I'll have to decide every petition.
Yes, no, not every petition. Basically, there are two issues.
Huh.
Post 18/1/23, whether there is
So
consequential
out of the
seniority,
two issues,
Ah.
one decision on the first issue, one decision on the next. issue.
basically consequential seniority. From, and in other round of litigations, my lord, that a collection of that quantifiable data.
That
aspect is there.
reservation and promotion,
Reservation,
that is 16A.
So that way, I think there will be three facets. One, two facets of consequential seniority, and other is, my lord, regarding
No,
whether to even to invoke
No,
the.
actually, why I asked this question, it may be, situation may be such, suppose I decide the writ appeal,
Yes.
the entire matter will again go back to the singular to decide individual writ petitions.
No, no. it's
Or
not
my
like-
decision in the writ appeal will cover those writ petitions also.
Up to a particular point of time and beyond 18/1/23,
It will, a particular aspect will be covered. Beyond that, it has to be decided
yes, in the
separate.
writ petition. And the another aspect is, my lord, whether while invoking the, power to promote, whether the requirement of collection of data and all this there. That is not by me.
Those
that is
Nagaraj
by-
and all those things.
That is by Minal Chaudhary, I think. He has hesitated those points. So as far as I am concerned, my lord, is consequential seniority.
So shall we start the hearing?
Yes.
or-
Look, my senior, Mr. VK, that's he's also out
You
of.
will hear him, he is a respondent. You can take note of what Mr. Chaudhary submitted, if you want, or if you want, no, we should not hear, tell it openly and frankly. Means this, little bit here, little bit there is difficult. Be open, be frank, say whatever you have to
No,
say.
Lord, your Lord,
Yes.
I'm just coming in.
Yes, please. Anyway, can we complete it today? I don't think so.
Today I cannot, my lord.
So yes, you can take your time also.
My lord, I've also placed one IA, my lord. Item 35, that lordship will permit me towards the end. Let me first place
That
the-
he says he wants to give some reply.
in mind.
35 would say that IFL would say.
Well, this is pending for the last 6 months. Why have you not filed?
IS voting defect.
Huh?
IFL.
আমি কোন নতুন কে file করেছি? It's a clarification. Oh, my lord, the time frame was not given. That's why government is not acting. We have prayed that time.
So if we
frame-
decide the whole thing, that will also be anyway covered up.
No, my lord, here in this case, my lord, in spite of everything, I am a scheduled tribe candidate, my lord. My name is above, I am senior also. I am not claiming consequential seniority for this benefit. Now I have been approved by the DPC also, they are not giving effect to the promotion.
So that's a separate issue.
That's it. Only thing is, my lord, since there is no time frame is given in the order, that's
the
why, my
court.
lord, they are
That's
not
right.
acting on it, yes. So we are praying that a time frame may be fixed.
My lord, I had to await that instruction. Well, that was the only thing.
No,
We received
Mr.
it last week.
Bitala, you see, if the matter has been decided and only remains is the
Time
time
frame.
frame not given, we can always put in a time frame
Correct.
because we'll not be otherwise
that I agree,
disturbing
my
the
lord.
order. But if it is something that the core issue in the order will be disturbed, then of course we'll have to
Yes, that-
have every objection from your side.
My lord, we-
Written argument ৰ copy টো আছে। খোলা বেলেগ এটা mail খোলা। এইটো কি? মই ইয়াত পঢ়া তোমালোকে। Will kindly give me 2 minutes time. Taken argument of copy. এতিয়া যে বনাইছো এতিয়া বনোৱাটো ফাইলটো মোক দিয়ে প্ৰণৱ কুমাৰ তুমি মোৰ ফাইলটো ক'ত হা এনেকুৱা আৰু আছে এইবিলাক ক'ত এইকেইটা এইটো কি এইটো ডিটেইল সাবমিশন Well, can I hand over to copy, my lord? My lord, though it is in item number kiman ko item.
Sandeep Bhattacharjee.
Ah.
Sandeep Bhattacharjee is. I think 35. No, not
Item 35.
35, I think.
Same issue, my lord.
1567.
May, if I read this, my lord, my entire perspective will be there.
It's a written submission.
It's a written submission.
Written submission before hearing.
My lord.
Written
No,
submission.
what I'm saying, my
before-
lord, I have not only incorporated the
No, no.
facts, I have also,
No. Written submission before the hearing has started.
my lord, same thing I will speak, so might as well. My lord. That in the writ petition, the petitioner has assailed legality and validity of recommendation of DPC dated 28/2/22 for promotion of officers in the rank of executive engineer to the rank of superintending engineers based on gradation list dated 17/2/22. This honorable court by order dated 13/03/03/2002 was pleased to direct not to make any promotion to the post of superintending engineer pursuant to the recommendation dated 28/2/22. Now, before adverting to the projections made by the petitioner in the writ petition, the answering respondent would like to put the facts and legal position with regard to accelerated promotion and consequential seniority in perspective. That as far as the state of Assam is concerned, the state legislature enacted the Assam Scheduled Caste and Scheduled Tribe, a reservation of Post in Service Act 78 to provide for reservation in favor of Scheduled Caste and Scheduled Tribe in matters of direct recruitment and promotion. Subsequently, by OM dated 3693, Government of Assam was pleased to extend the benefit of reservation in direct recruitment to OBC and MOBC. Section 5 of the Act of 78 provides for reservation in favor of Scheduled Caste and Scheduled Tribe in matters of promotion, which benefit was, however, not extended to OBC and MOBC. Another important aspect which needs to be highlighted is that under the Act of 1978, the roster is to be filled up on the basis of vacancy, a practice which was deprecated by the Honorable Supreme Court in Sabharwal's case, wherein Apex Court held that cadre strength is always measured by the number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect of a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which form the cadre strength. The concept of vacancy has no relevance in operating the percentage of reservation. That in the meantime, the law relating to reservation received a different interpretation in Nagras. The Apex Court, while upholding the validity of the Article 16.4a and 16.4b, held that the impugned constitutional amendments are enabling in nature, and amendment left it to the states to provide for reservation in promotion. It was observed that if appropriate government enacts a law providing reservation without keeping in mind the parameters of Article 16.4, 335, then court will certainly set aside and strike down such legislation. The Apex Court at para 119 of the report also held that concept of reservation in Article 16.4 is hedged by three constitutional requirements, namely backwardness.
Report means para 119 of the.
Of this, my lord,
What
Nagras.
report?
Nagras.
Nagras.
2006 8 SEC.
Also
Is
hedged
hedged by three constitutional requirements, namely backwardness of a class, inadequacy of representation is public employment of that class, and overall efficiency of administration. Thus, at para 123, the Apex Court held that state concern is not bound to make reservation for SC/ST in matters of promotion. If the state concern decides to provide for reservation in matters of promotion, in such an event, state will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall efficiency of administration. Thus, the state of Assam, having regard to observation in R.K. Sabharwal and Nagras, amended the Act of 78 by Assam Act 19 of 2012, wherein Section 5 capital A, in Section 5A, the manner and procedure for giving effect to reservation has been prescribed. Section 5A3 provides that roster is to be operated on the principle of replacement and not as a running account. Under the Amendment Act of 19 of 2012, the earlier vacancy-based roster available under Act of 78 was replaced by a post-based roster. That in the judgment dated 6/6 so and so, this is the judgment challenged it, my lord, in the writ appeal.
Yes.
The learned single judge dealt with two aspects. Whether there is requirement of collection of data with regard to inadequacy of representation, as mentioned in Article 16.4, and overall efficiency of administration.
One pathar is the impugned judgment in the appeal.
In the writ appeal. The other aspect was whether in the state of Assam, the benefit of consequential seniority extended to roster promoters while OM dated 12/3/2002 is still available. In the present list, later issue arises for consideration, including that writ appeal, including in this batch of cases.
Just a minute. When was this act amended? Act 5 of
2012, my lord. 2012.
2012?
12. My lord, after
The date of amendment is 20.
Act 19 of 2012. Assam Act 19 of 2012.
No, but from which date?
One second. I'm giving my lord. Page 251.
Well.
My lord, 21st of August.
2108, 2012.
Yes,
12.
my lord, I have tried to trace the history and then, my lord, what is the issue which falls for consideration and what is our.
And what did the OM of the 12/3/2002 provides for?
It provides that they will be entitled to consequential.
Consequential seniority. And that is as per vacancy based.
That was vacancy.
Vacancy based. Now after 2012, it has become post based, only by replacement.
Yes, replacement. Earlier it was running account.
So if it is replacement,
That means, my
whether
lord,
consequential seniority will still be available. That is the issue.
no, consequential, yes, whether it will still be available.
After being converted to this, what you call post base or replacement basis,
Yes,
whether
yes.
it will still be available. That is the issue to be discussed.
Yes, that is the only issue. Then I'm reading para 5, my lord. That what is significant to notice from that judgment in Nagaraj is that Article 16(4)(a) and 4(b) have been held to be enabling in nature, and a state is not bound to make reservation for scheduled caste and scheduled tribe in matters of promotion, much less consequential seniority. It is for the state concerned to make such a provision, and if state decides to make such a provision, then it is imperative for the state to collect data with regard to inadequacy of representation, Article 16(4), and overall efficiency of administration, 335. This is pursuant to Jarnail Singh, my lord. Initially, backwardness was also there in Nagraj, but in Jarnail Singh, it was said that since the,
I think taken away something.
yes, from the constitutional scheme and the case law, it is not possible to discern that consequential seniority is automatic, in as much as state concern will have to make provision not only for reservation in promotion, state concerns will also have to make provision for consequential seniority. That pursuant to the decision of the apex court in Virpal Singh Chauhan, State of Assam was pleased to issue OM dated 12/6/96, whereby it was provided that a general category candidate will regain his seniority over the roster promotee who earned his promotion earlier by virtue of roster. In other words, OM introduced catch-up principle in the matter of fixation of seniority. That consequent upon amendment of Article 16(4)(a), State of Assam issued OM dated 12/3/02, which inter alia provide that SC/ST government servant shall on their promotion by virtue of rule of reservation be entitled to consequential seniority with effect from 17/6/95. That is the date of the constitutional amendment. That when OM dated 12/3/02 was issued by the state government, legal position which emerged post M. Nagraj, that Article 16(4)(a) is an enabling provision, then that the state is not bound to make reservation in promotion was not settled. Under the circumstances, the state proceeded as if there is a mandate to provide consequential seniority also to roster promotees. It was on the aforesaid premise that OM dated so-and-so was issued and operated.
Nagraj is subsequent, right?
Yes, 2008, my lord.
8. This is 2008.
Yes. Consequent upon amendment of the Assam Act of 78 by the Act 19 of 2012, Government of Assam issued OM dated 29/12/14, which inter alia provided for preparation of rosters, etc. Clause 1.11 of the said OM provides that rosters are an aid to determine the entitlement of different categories with regard to quota reserved for them in matters of appointment. They are not intended to determine seniority in the category. The clause 14.
Just a minute. Government of Assam OM 14. Preparation of rosters, etc. Rosters are an aid to determine entitlement to quota for them. They are not intended to determine seniority in detail.
Yes.
This is interpretation of the appellant.
No, my lord. This is the exact wording in the
Wording of
OM.
the
That's why
OM.
they put it in italics. Clause 14 of the said OM provides that all orders on the subject, including OM dated, including is our emphasis, my lord, are deemed to have been amended to that extent therein. That pursuant to the judgment dated 23/12/15 of the Honorable Court in WPC number so-and-so Equality Forum,
wherein it was held that if the state desired to give effect to promote reservation in promotion, it would have to justify the same with the help of quantifiable data. Government of Assam issued OM dated 3816 after reviewing the existing procedure of effecting reservation in promotion. Clause 4 of the said OM provides as follows. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion, her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of accelerated promotion earlier. In other words, my lord, a reserve category candidate who has earned a roster promotion, say from grade A to grade B, my lord, but for promotion to grade C, his case will be considered only if he haven't earned a roster promotion. Because, my lord, while earning a roster promotion, there was no inter-C assessment of merit. Who are the general candidates? Merely because of roster is a replacement. One reserve category will replace another. So, if there is in the promotional cadre there's a post reserved for reserve category, that's a different issue. But against the general post,
what I understood,
yes.
if in your earlier promotions, you were not the beneficiary of reservation by promotion,
then you will be considered.
Otherwise, you are entitled on merit, you can be considered.
Yes.
But in your previous promotions, you are a beneficiary of reservation, you will not be entitled even for merit consideration.
That's the position. That it will thus be noticed that after issuance of OM dated 12/3/2002, which conferred benefit of consequential seniority to roster promotees, various changes have taken place in the legal scenario as explained herein above. By necessary implication, if not expressly, roster promotee is not entitled to consequential seniority with effect from 29/12/14 and subsequent dates. Now, following issuance of OM dated 18/1/23, that is why I am saying, my lord, now state has expressly said no consequential seniority with effect from this date. So prior to this date, our prayer would be, Lordship would say, by necessary implication, consequential seniority was not there because there was no express repeal. With effect from 18/1/23, expressly in the OM dated said that for class A, you will not get consequential seniority.
Sorry, please repeat the dates one again. From 29/12/2014.
My lord, from 2002, it continued. So they not only got roster promotion, they also got consequential seniority. 29/12/14, they come up with that OM, whereby it was said that the promotion which you have earned, it will not be for the purpose of seniority. It is only a promotion. So that's why we are saying, my lord, with effect from 29/12/2014.
That is, rosters are for an aid to determine entitlement.
Yes.
And they are not intended to determine seniority.
So that means your accelerated promotion will not confer you consequential seniority.
This is taken away by 2014 OM.
So that's why I'm saying, my lord, let me read this paragraph, then the faction will extremely clear. Now following issuance of OM dated 18/1/23, though Government of Assam has decided to pursue the policy of reservation in promotion in all posts, but in respect of Group A services, it has been decided that roster promotees on their accelerated promotion shall not be entitled to consequential seniority. So now, my lord, state has expressly said, with effect from this date, there will be no consequential seniority. In other words, OM dated 18/1/23 recognizes the right of unreserved candidates to regain seniority in the promoted cadre by application of the catch-up principle. That in the circumstances, a pertinent question arises for consideration in the present list. That is whether OM dated 12/3/2002 lost its efficacy with effect from 29/12/14, when Government of Assam, pursuant to the decision in M. Nagaraj and Amendment Act of 2012, issued OM dated 29/12/14, wherein it was specifically provided rosters are not intended to determine seniority in the promoted cadre. Even assuming, while not admitting, that OM dated 29/12/14 did not expressly repeal OM dated 12/3/2002, but by necessary implication, it can certainly be asserted that OM dated 29/12/14 was issued to override OM dated 12/3/2002. Further, issuance of OM dated 3/8/16 referred to above sets and rest the above controversy. It is a well-settled principle of law that there is a presumption against an implied repeal, but this presumption will stand rebutted if provisions of the new OM, that is 29/12/14 and 3/8/16, are so inconsistent with the old one, that is 12/3/2002, that the two cannot stand together. That's a judgment of the Supreme Court, my lord. What follows from the above is that catch-up principle evolved by Honorable Supreme Court revived with effect from 29/12/14 until 17/1/23 by necessary implication, and expressly with effect from 18/1/23. So this is, my lord, our projection. So this is our basically case, my lord.
This is what we have to decide.
Yes, this is what we intend to, my lord, canvass, my lord. So that's why I put it in writing, my lord. It saves everybody's time, my lord. And I've cited the relevant case laws also. There's another facet to it. Let me read, my lord, paragraph, only one paragraph. That the basic prayer of the petitioner is that seniority of the petitioner in the gradation list prepared for the cadre of superintending engineer be prepared as per rules of 22 and 24 of the service rule, which any view of the matter cannot be accepted. The apex court in Ajit Singh Juneja at para 9 dealt with the precise issue. Explaining the purport of the roster promotion, the apex court observed that accelerated promotion are to be made only against post-reserve or roster prescribed. The roster promoters who earn promotion by application of roster before their seniors in the lower grade belonging to the general category, the roster promoters do not supersede the general candidates in the process because there is no inter-se assessment of merit between them. As such, when such seniors who belong to general category are promoted later, it cannot be said they have been superseded by roster
This
promoters.
judgment is still surviving.
Yes.
After all the
Yes,
subsequent,
yes,
this is still surviving.
Yes, man. So after all the ups and downs. As such, when such senior who belong to general category are promoted, later it cannot be said that they have been superseded by roster promoters who have been promoted earlier. This observation of the apex court notice above conclusively establishes that claim of the petitioner roster promotee for fixation of seniority as per Rule 22 and 24 of the service rule is not only misconceived, but is also untenable. My lord, now they are saying apply Rule 24 and 24, 22 and 24 for determination of seniority. When you earn the promotion, did you earn according to the rules? Did the DPC recommended you? There your inter-se merit was never assessed. Only because you belong to a particular category, there is a constitutional provision. So before that, you have been picked up and placed in that slot.
There is no determination.
Nothing, my lord. So now they are saying, fix the seniority once, my lord. In other words, they are trying to say the catch-up principle is not applicable. My lord, Supreme Court in clear terms in my lord, Supreme Court has said, the moment there is no, my lord, accelerated consequential seniority, the catch-up principle automatically revives.
Yes. That has to be by default.
Case, my lord.
Anyway, by default it will come.
Yes.
Because one of the two has to exist.
My lord, I have heard my friend Mr. Dikedas making the argument. His only case is, my lord, that accelerated promotion and consequential seniority is a constitutional mandate flowing from Article 16(4)(a). That is his case. Now, my lord, I'll just refer to that one passage from that Panir Silvam, my lord, where this proposition has been, my lord, over. I'm just reading it. I'll give it in due time, my lord. The division bench appears to have proceeded on an erroneous footing that Article 16(4)(a) of the Constitution automatically gives consequential seniority in addition to accelerated promotion to the roster point promotees, and the judgment of the division bench cannot be sustained. This was the precise argument, my lord, in Panir Silvam, which Supreme Court has expressly rejected.
So we
now,
have to interpret 16(4)(a), whether it is enabling or whether it is it's a mandate.
It's enabling, my lord. So that is how I propose to deal with it, my lord. Now, my lord, so therefore, my lord, the case which I'll be projecting for your lordship's kind consideration is that a roster promotee is not entitled to consequential seniority. The moment,
From 2023, no,
no,
this has been clarified.
yes.
Now, only the in-between period of 2014 to
There they have
2023.
challenged that. That
2023 is also under challenge.
By them.
Where is the challenge here?
Yes, in this.
Here only.
Ah.
Okay. Mhm.
That's why I filed the affidavit, my lord, and my lord. In the affidavit also I have explained the
In
same.
which
position.
writ petition it is under challenge?
These are. My lord, item number 37.
37.
These are new writ petitions where this subsequent OM has been challenged.
Now, my lord, for the purpose of period post 18/1/23,
Mr. Betala, what, after hearing Mr. Chaudhary, what I understand, I think we'll have to deliver separate judgments in some of the petitions.
yes.
Yes, my lord.
It may not be one common judgment
Yes,
merely
yes.
because
No,
everything
yes,
is the which.
no.
We have to go petition by petition, issue by issue,
Yes, but the
possibly.
first would be the. writ
And
appeal would be
maybe
decided.
a couple of petitions can be
Clubbed.
Group
decided
together.
in a bunch,
Yes,
but not all.
not all, correct.
Mhm.
The first would be the writ appeal.
Let
And
us
these-
first deal with the writ appeal. Writ appeal,
Yes.
what Mr. Chaudhary is submitting is between the period of 2014 and 2023, how we have to look at it.
Yes. One of the.
Whether there is any implied repeal or the way it is projected, because evidently there is no express repeal.
Yes.
Then we'll have to interpret what is.
My lord, in fact, that is what a single judge has said. That's why we are before your lordship.
We have to interpret that 29/12/2014, which
Yes.
says that rosters are an aid to determine the entitlement,
Yes.
and they are not intended to determine seniority. What exactly it means?
Yes.
Then comes that
3816.
16.
Which says a reserved category candidate who has earned promotion by roster, he will not be considered for further promotion against general category post.
Again, general category
Yes.
post.
If there is a post, because it is by replacement.
So
Because-
even if he is on merit, he'll not be
No,
considered.
no.
And that is under challenge.
That was under challenge in Bhagwan Pater's case.
Has it been decided?
Yes, my lord,
Yes.
that issue is.
Decided which way?
My lord, that.
In favor of the reserved category.
Reserve candidate.
That that they will get.
Yes,
Bhagavan Pater is that.
that judgment. Just have referred in the middle of the, my lord, written
No,
argument.
Bhagavan Pater is this writ appeal.
Yes, my lord,
In
that
fact,
is
my
under
lord,
challenge.
IV Guhai, that is where we have challenged. that.
28. IV Buragohai is that Bhagavan Pater only.
Yes,
Yes,
against the
challenge
Bhagavan Pater.
Bhagavan Pater, it was decided that
That a person.
in
on
spite of this, the reserved category will continue to get their
Position in merit also.
position in merit also,
Also.
apart from their
Accelerated
promotion.
Yes. They will be.
So
entitled on
after
merit.
attaining one or two accelerated promotion, if a given candidate is this time he is fit on merit,
Yes,
the other reserved category will take the benefit of accelerated promotion, but this man will come and compete with the on merit with others.
yes, my lord, he can compete either on merit or he can go as an unreserved category.
Anyway, if he fails in merit, then he will be considered under the reservation.
Yes, my lord,
If he
Either
succeeds in merit,
absolutely.
he'll get it.
Lordships. Yes, that was a help.
Okay.
My lord will kindly take the writ appeal now, my lord. My lord will kindly come to.
Mr. Makhan Phokan, what will he do?
Now.
The way this matter is going, I most unlikely will.
Some other
do
day after then.
Some other day. Are you prepared? Did
Mother,
you get
I'm
something?
prepared, plus prepared.
Did you get something?
My lord,
Did you get something?
yes, my learned friend has get something.
Which way? It can be done or cannot be done?
My lord, he carries some circular where
Right.
it shows, my lord, the qualifications of the legal officers and all, my lord, the DIG.
No, we are not on qualification.
My lord, yes. But otherwise, they did not find any.
No, we are not on exactly on qualification.
Lordship.
See, district judge also is the qualification of LLB,
Lordship.
nothing beyond that. Can any LLB now decide a 302 matter?
My lord, that is the main
Or
issue.
it is only a district session judge because of his intervening experience, his developing that acumen, understanding the law, and then he does it.
Some circular is there, Lordship.
I understand. No, we are not against you, we are just thinking. And how safe it will be,
Lordship.
how safe it will be to decide it 302 by a person who only has that academic qualification, but not otherwise, and the man otherwise must be doing some other work.
Lordship,
As his regular vocation, he must be doing some other work.
it's like a jury system, Lordship.
Sorry,
It's like a jury system, Lordship. GFSC code, it's a jury system.
no, how comfortable will a person be? Because 302 is one of the most complicated law. Had it been only one line, that if one man causes death of another, it's 302, then there is no absolute difficulty. Anybody can decide. He will only take evidence on the fact whether X had killed Y or not. Moment it is established X had killed Y, straight away 302. But 302 is much beyond that. And this knowledge you acquire only by virtue of your experience, you are dealing with the matters, your in-depth study of the legal provisions, then you are well adapted to decide a 302. There are hundreds of circumstances. Circumstance a little decide, decision will be one. Circumstance a little the other side, decision will be another. Both case the man had killed another man. So our question is whether your officers is they are adequately prepared for that. Qualified, yes, you have the degree, but are you prepared?
Lordship, one circular is that 10 years of experience in.
In what? In dealing with ordinary legal issues.
Lordship, that to 302.
See, this is why we are putting it across you. Mr. Chaudhary, just 1 minute. Anyway. This is why we are putting it across you. Even to appoint an amicus in a criminal appeal matter, High Court requires 10 years of experience of that lawyer. We don't put a fresher straight away. Why? And not only 10 years of experience, we also see what kind of experience the person has in that criminal law. Not just mere documents that I have 10 years of practice. Why are these requirements put in? If everybody can do it. After all, you are dealing with Article 21, mind you. It's a fundamental right. So therefore, we are asking this larger question. Your circulars may justify your aspect, but is the core issue answered? Let us take it the other way. You want to go for a complicated heart surgery. Medical documents provide that a doctor of only having the qualification of MS surgery and having this thing can perform a heart surgery. Suppose that's the rule. Will you allow the doctor to open up your heart? Or you will go to the person who is well versed with that heart surgery? Will you ever allow somebody to open your heart? Merely because that man has a MS surgery? Is it not the same situation in a legal issue? Yes, what answer we have? We refer to some circular. We are repeating the same question again. Technically, yes, it has been something is done, something provided he meets it.
That is what I have seen, Lordship, my instructions, Lordship. It is more in the form of a jury system. where there are
Jury system is again another factor. Jury system is what mentally the society thinks about it. That is basically a jury. Juries are not legally trained. Basically, what society thinks, that is a
what,
jury.
there are 5 people and there is a law officer who will sum it up and place it before them. And ultimately they take the call.
This is why we put one question to Madam Sharma. Suppose you are required to do a complicated heart surgery. Qualification of surgeon is MS. A postgraduate degree in surgery is good enough. Will you allow any MS doctor having MS qualification to open up your heart? Or you will go to the choices of the doctor to find out?
That is.
From the same principle, why do you subject these people to that?
That, at one point of time, somebody has to take a call, but
Is it decided anywhere? No.
Lordship,
Has this issue ever arisen anywhere?
not particularly on this issue, but then
The other aspect we agree. Your court martial will deal with his status as
as a court.
as a member of the armed forces.
Yes.
You dismiss him, you do whatever you want to do with him.
Particularly this aspect, I have not come across, Lordship. Because power is there, all right. But the persons who are exercising that power which has fallen from your lordship, that I have not come across. Because ultimately it is the
When do you want the matter?
lordship.
When do you want the matter? Possibly today this will not be over. Choose your date.
Lordship will give me a slightly longish time.
Choose your date. Fix it accordingly. But think it from that point of view.
Yes,
Will one person be ever allowed to merely a doctor who has the master surgery to open up his heart?
Precisely that, lordship. I had called these officers and they are only on the.
Sorry.
I had called the officers of the BSF and their version is lordship is the jury said this.
Circular. कर सकते हैं. There's a difference between कर सकते हैं and whether you can appropriately do it or not.
That aspect has to be looked into at some point of time, lordship. Lordship will take it after 3 weeks, lordship. I try to do something.
Lordship.
As paid by Mr. M. Khokon and Mr. Akeli Chavil and for the petitioner and Mr. Akeli Chavil and you as well. List the matter on.
Much of
Power to exercise. Yes. My lord will kindly come to page 44 of the writ appeal. This is that 12th of March 2002. When?
Overall. Yeah, I got tech book খুলি দিয়েছে confusion I got technical was ভাল আগতে গোটে কোনোবাই শুনিছিলে ওপৰৰ কেইটা নালাগে সাইডৰ ওপৰ
In Supreme Court number, my lord, court number 1, absolutely paperless.
We don't mind.
I think it will take some time, my lord, to get used to that. Of course, we should start.
No, why I say I don't mind? Because in between for almost 2 to 3 months.
Yes, during COVID time, my lord.
No, I conducted a court from my residence, absolutely paperless. Nothing went to my house. It can be done if
I
you
think
want.
Chief Justice Dhulia, during his entire tenure, I don't think he has, it was online, my lord. But we could notice he used to sit with this, my lord, laptop.
No, no, in between for, I think, for 2 months, I believe.
Ah.
It was absolutely, it was done from home
Yes,
and not a single paper went to my residence.
during that COVID time. Anyway, my lord,
Everything,
kindly come.
including your those appeals and this and
Yes.
all kind of matters. It can be
Page
done if you want.
44, my lord. Consequent upon amendment of Article 16(4)(a) of the Constitution of India by the Constitution 85th Amendment Act 2001, it has been decided that the following principle of fixation of seniority for reserve candidate vis-a-vis general candidates in promotional posts shall be followed. Scheduled caste, scheduled tribe government servants shall on their promotion by virtue of rule of reservation roster be entitled to consequential seniority also, and the above decision shall be effective from 17/6/95. Now, the issue which we are raising is, my lord, the benefit which flew to, my lord, reserve category candidates by virtue of, and my lord, because reservation can be operated by executive instruction, so therefore there is no dispute on that.
This is OM, Office
Yes.
Manager decided it.
In the written argument, I have said that this was issued primarily based on 16(4)(a). At that point of time, my lord, the legal position which emerged post Nagraj, that it is an enabling provision that could not be perceived by anyone. When, my lord,
Okay, when this OM was put in place,
Yes.
Nagaraj was not there.
not there,
And the concept of enabling provision was not there.
not there.
It was understood to be a mandate of the Constitution.
As if it flows straight away from, my lord, Article 16(4)(a). এরকম কি বলি? My lord, prior to this, there was a circular of 12th of June 96. That, I'm sorry, my lord, Lordship will kindly take my written argument, first page 11 of that. Please come to page 11 of that document, my lord. This was contra, it was said otherwise. Fixation of seniority of reserve candidate vis-a-vis general candidates in promoted post. The Supreme Court of India in a judgment dated 10/10/95, as reported in so-and-so, had held that while reserve candidates are entitled to accelerated promotion, they would not be entitled to consequential seniority. While the rule of reservation shall be applied and roster followed in matter of promotion to or within a particular service class or category, the candidate promoted earlier by virtue of rule of reservation, roster shall not be entitled to seniority over his senior in the feather category, and that as and when a general candidate who was senior to him in the feather category is promoted, such general candidate will regain his seniority over reserve candidate, notwithstanding that he is promoted subsequent to the reserve candidate. This principle would be operated from February 10, 1995. My lord, what had happened in this Virpal Singh Chauhan, my lord, there was a railway board circular. Railway board circular said, my lord, that even if a reserve roster promotee gets a promotion earlier, however, while he is in the promoted cadre, if a general category also earns a promotion in the meantime, then the general category principle will catch up. That was not law, my lord. It was a judgment in the facts of the case of my lord, Virpal Singh Chauhan.
Which one?
My lord, this circular of 96 was based on the decision of Virpal Singh Chauhan. I'm just indicating, my lord. Here it said the catch-up principle will divide, or rather catch-up principle will apply. The moment a reserve category, sorry. My lord, this.
Chaudhary is thinking of that only, what you were trying to say. If you go to that 96, Virpal Chauhan.
Yes.
Virpal Chauhan specifically provided no consequential seniority.
No, Virpal Singh says, yes, no
consequential seniority.
Yeah, I'm sorry, madam. Yes, correct.
That is Virpal Chauhan. Then again in the last paragraph said, it is therefore decided. Okay. Now take note of the word decided.
Yes.
Firstly, court has specifically provided no consequential seniority. They again decide also. Now come to the 2002, page 44.
Yes, my lord.
Consequent upon amendment of Article 16(4)(a). So they are following 64(a). Again, it has been decided.
Decided.
So decided means Supreme Court having specifically provided, instead of adopting it, government is deciding.
They could have provided.
No,
They could not have
provided.
decided.
So they decide. Now, how you understand this word decide here? This is provided or this is decided?
It should be read as
No,
provided.
if it is provided, then it was understood that it's a constitutional mandate.
Yes.
If it is decided, in spite of it being a decision pre-Nagraj, they have decided and thought it that in exercise of the enabling power, we will provide for it. Now,
No, 16(4)(a) was not there, my lord, when 96 was issued.
understand? Although it is not there, no, 96 not there. In 2002, it is there.
Yes, 2002.
So now 2002 brings in that enabling provision that you can also provide for consequential benefit.
And it is for the state.
So now I was trying to understand that this is understanding that consequential seniority provision to be a constitutional mandate or an enabling provision, what they have done. Confusion arises because they have decided. In Virpal Chauhan also they have decided.
Supreme Court has decided.
But no, government again decided. It is
Yes,
therefore
yes,
decided.
again decided.
So now we don't know the meaning of the word decided. We have to understand, Mr. Muzumdar. Had one been provided and the other been decided, we could have understood that they used it as an enabling provision, in spite of it being not clarified in Nagraj.
Correct. Anyway, my lord, and for just for the, my lord, narration of facts, I'm putting it. Now, my lord, therefore, in 96, the position was general category will regain seniority. 2002, no. It is case of consequential
In the
seniority.
meantime, 85th amendment comes in.
Now, my lord will kindly come to 29-12-14 at page 45. May I read, my lord? Consequent upon the amendment made in the Assam Scheduled Caste and Scheduled Tribe Act of 78 and acceptance of the recommendation of the one-man commission constituted by Government of Assam by notification number so and so, which Sri Harish Sanwal IS as the commission to study and acquire quantifiable data on backwardness of the scheduled caste and scheduled tribe, their inadequacy of representation in government service and post, and impact in overall efficiency in public administration. The following guidelines have been prescribed in order to implement post-based roster reservation in matters of reservation of posts for scheduled caste and scheduled tribes in direct recruitment and promotion. Now, my lord will kindly come to 1.11, the same page towards the bottom. Dangerous comes to this.
In which decision it was said post-based and not a vacancy-based, a replacement?
My lord.
You refer to one something called replacement.
My lord will kindly come to section 5A,
No, no,
5A of the act.
no, in your note somewhere.
Yes, yes, I said,
it said
I'll
somewhere.
show.
Somewhere you said it is.
I'll just show it.
No, running replacement, para 4,
Page
Roman
4.
3.
Ah.
Roman 3. This is pursuant to 5A. 5A.
Yes.
5A is 2012.
By 2012 amendment.
2012, yes.
My lord will kindly come to page 45.
Hmm.
So I'll have your lordship's attention to 1.11, my lord, towards the bottom. These rosters are an aid to determine the entitlement of different categories with regard to the quota reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the cadre. So, my lord, this is as crystal as water. These, I'm reading it again. These rosters are an aid to determine the entitlement of different categories with regard to the quota reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the cadre. That means a roster promotion is not determinative of the seniority which you will earn in the promoted cadre. No relation. Then my lord will kindly come to page number 49, my lord. 6 or what? 49. Oh, page 49, para 14, my lord. Please to be on.
Yes, sorry.
My lord will
Page
kindly come to
49.
page 49, my lord, para 14. All existing orders on the subject are deemed to have been amended to the extent herein. According to me, my lord, subject to what your lordships may say, 12/3/2002 is superseded by this para 14.
Deemed to be amended.
Yes,
Legal fiction.
deemed to have been. My lord, let us, I'll make my submission, my lord, by applying both express as well as repeal. How can my lord 12/3/2002 and this and 3/8/16 survive together? Because one says you will get consequential seniority, one says you will not. That means there is express implied repeal also, my lord, if not express. Then my lord will kindly come to the next page. Page 50. May I read page 50, my lord?
No, just one.
One second.
In 2002, they provided this instruction contained of 1996 stands withdrawn.
Withdrawn.
So
That-
there it was expressed
It was expressed.
when a consequential brought
Yes,
in.
yes, yes.
Now it is not expressed.
Not
One
expressed.
is not intended. Other it says deemed to have been amended. The extent herein above. So consequential seniority remains.
Well, by 14 may not, my lord.
No,
That
no,
would be my
that's what-
submission.
No, no, we are just asking you.
Yes.
We're not forming any view.
Yes, yes. Tentative view, my lord.
Because all that 14 says is that
My lord, may I
that,
just come in? May I just come in, my lord?
uh,
For the present, my lord, let me place the another circular, then I will come to one judgment of the Supreme Court. Wherefrom I'll satisfy your lordship that it was a case of implied repeal.
no, we are sure.
Let us not test it from the perspective of express repeal.
No, no,
Ah.
no, we'll hear you, no difficulty. No, we are just on 2014.
Yes, yes. It says all
2002,
existing.
when it says 1996 withdrawn. It's very
Yes,
clear,
express.
explicit. 2014 is consequent upon amendment to the 1978.
Ah.
That is the 2012 amendment.
Yes,
What does it provide for? It says the principle of replacement will come in
yes.
instead of a running roster.
Running account.
So this is consequent to that means they want to bring in
Ah.
the concept of replacement.
No, I'll ask your lordships to read clause 14 in the context of 111.
No, we'll read.
Ah.
Let us read one by one.
Yes,
So this is for the context of to implement a post-based roster, that is concept of replacement. In doing so, what 111 says, these rosters are an aid to determine the entitlement.
Of different categories
Different categories with regard to quota reserve,
for them.
matters of appointment and
And
promotion. And promotion. So these rosters are an aid to determine. So these rosters are now clarified to say that this will be post-based and not a running roster based.
Yes.
They are not intended to determine seniority in the cadre.
Okay.
This post-base is not intended to determine the seniority. This line has to be
Given
understood
a meaning.
what it means. Now, whatever meaning can be given to that,
Yes.
14 says all existing orders on the subject are deemed to have been amended. So amended as provided in 2014.
Yes.
Whatever may have been provided in earlier ones, 14 says it is all
Stands
earlier
amended.
ones are deemed amended subject to what is provided here.
Yes.
So now we'll be required to interpret what does this mean? They are not intended to determine seniority.
That's why I say, my lord, perhaps 12/3/2002 will continue until 28/12/2014, not with effect from 29/12/14. So that benefit will continue until 28/12/2014.
They did not come.
Yes. With effect from 28/12/14.
So now we'll have to give a meaning to this line.
Yes.
They are not intended to determine seniority in the cadre, what exactly it means.
My lord. And lordship, what had happened, my lord, during the course of the proceedings before the learned single judge. In fact, your lordships had the occasion to ask the government, lordship would recollect, to file an affidavit as to where.
That is a difficulty. We don't recollect anything.
No, my lord. And all right, let me say,
everything is
learned
a
single
affidavit.
judge of this honorable court, requested the learned additional advocate general to place the
See,
view of the government,
To
whether.
the extent we don't remember, when after hearing for some time, we adjourn it for the time being
Yes.
to be taken up later on. When you take up, it's complete blank. You don't remember anything. You have
Possible
to,
also. So
and-
many matters.
and if you remember, you cannot take up the next matter. For the next matter, you
Yes,
have
yes.
to empty yourself.
Everything has to be empty.
Otherwise, the next matter will be distorted. So this remembering, it's almost not there.
Anyway, then my lord will kindly come to page 50, my lord.
Page 50.
50, yes. Now this is 3816.
This is as per the guide, this.
Yeah, review of the
Nagraj.
government policy of reservation in promotion with reference to Honorable Guwahati High Court judgments. As per the guideline laid down by the Apex Court in Nagraj, UP Power Corporation, the government of Assam has prescribed procedure as to how to implement the policy of reservation in promotion via OM dated 29/12/14. The report of the one-man commission on quantifiable data was accepted by the state government with approval of the state cabinet. Accordingly, on the basis of the report, the government decided to provide reservation in promotion. This provision for reservation in promotion were also incorporated in the aforesaid office memorandum. However, the report of the commission was challenged by the Honorable High Court in the Equality Forum. The High Court observed that though state has made provision for reservation in promotion by enacting the Act of 1978 Act, which was amended in the year 2012, implementation of the same would depend on acquiring of quantifiable data with regard to two compelling reasons, which exercise has to be carried out otherwise in the context of service where cadre is placed. That having been not done, the report of the one-man commission would be of no legal consequence and would not enable the state to give effect to the provisions of 78 Act as amended insofar as reservation in promotion is concerned. The government of Assam, after careful examination of the observations of the Guwahati High Court contained in judgment dated so and so, have come to the conclusion that the High Court has not set aside the government policy of
Why this
reservation.
was said, state has made provision for reservation by enacting the Act of 78, which was amended in
Malan, this was
2012.
actually, Malan, what had happened? The one-
Implementation of the same would depend on acquiring quantified data. What does it mean?
Malan,
With
this was
regard to consolidated agreement.
what had happened, my lord. The one-man commission did an exercise to find out the quantifiable data. In that exercise, some infirmities were noticed by the Honorable High Court in the Equality Forum judgment.
That was interfered.
Yes, they interfered. Thereafter, my lord, this guideline was issued. Now, this is how it came. I'll have your lordship's attention to paragraph 4 at page 52. Page 52. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion, his or her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of accelerated promotion. My lord, if it would have been the intention of the authority or the government.
This was challenged in that Pator.
Yes, not, yes, in Pator and other case, yes.
I think ultimately this straight appeal only.
Yes, correct. So, my lord, had it been the intention of the government to confer consequential seniority, then government would not have made this provision. So, what was implicit in my lord 29/12/14, in my humble submission, my lord, it has been made explicit in on 3/8/16. It says a roster promotee, he can, even if he is in the zone of consideration, he cannot be considered against a post reserved for unreserved or rather for open category. The reason is when you earned the promotion earlier, it was a roster promotion because you never competed with any reserve general category candidates. Your promotion was only by way of a roster replacement because you belong to say SC.
That not competed is provided in which judgment? I read it once in your note.
Yes, yes.
And that not competed with others.
Yes, Ajit Singh, my lord.
Ajit Singh Dhanuja, that one.
Ajit Singh. So, my lord, now, my lord, the question is, before that, I'll place two paragraphs, my lord. Now, my lord will kindly come to page number 138 of the memo of appeal. Now, before the learned single judge, this is the affidavit which was filed by the state. Para 8, my lord.
Which page you are referring?
138, my lord. This was an affidavit filed by the state, my lord, in the present writ petition before the learned single judge.
138.
Yes.
State affidavit.
Yes, my lord. That with regard to the statement made in paragraph 7 of the writ petition, your deponent begs to state that OM dated 12/3/2002, issued by the Personnel B Department, following the amendment to Article 16(4)(a), has been rendered null and void by subsequent judicial pronouncement as well as amendment of the SC/ST Act 2012, wherein state government did not incorporate enabling provision of consequential seniority. Moreover, the OM dated 3/8/16 issued by WBTBC Department reiterates the decision of the Government of Assam in the aforesaid Amendment Act of 2012 regarding their position in relation to consequential seniority. So this was the, my lord, express stand of the government. Then, my lord, what happened?
No, in 2012, was the consequential seniority taken away?
No.
2012?
2012, no, my lord. It was taken away according
They
to
only
us.
say it will be
29.
it will be replacement.
Replacement.
It did not incorporate.
Actually, my lord, no provision was incorporated
Hmm.
in the 2012 amendment, that is state C.
Hmm.
My lordship knows reservation can be effected by law as well as by executive instruction. So that 12/3/2002 was also is a law
Hmm.
within the meaning of my lord 16(4)(a).
Hmm.
So it is in that context, state said that we did not incorporate any provision regarding consequential seniority. All that the state in the amendment provided was there will be reservation in direct recruitment and promotion.
2012.
Yeah.
12 comes somewhere, right? 582, 2012.
My lord will kindly come to 251, my lord.
Schedule post based or something. এখন থাকিবও পাৰে পুৰণা নেকি 2012 আগৰ কিতাপ নেকি
It starts at page 251, my lord.
নহয়
My lord, Assam Scheduled Caste and Scheduled Tribe Reservation of Post in Service Act 1978.
but there is one of 1978.
Other lordships got it, my
Yes.
lord. Yes. Please come to section 5A, my lord.
Hmm.
The reservation for members of scheduled caste and scheduled tribe in service or post in an establishment shall be given effect to in the following manner. My lord will kindly come to clause Roman 3.
Post-based roster.
The roster is to be operated on the principle of replacement and not as a running account. In other words, the point at which reservation for different categories applies are fixed as per the roster, and vacancies caused by retirement, etc. of person occupying those points shall be filled up by appointment of person of the respective categories.
Suppose we understand the situation
My lord.
that somebody had the benefit of promotion at the age of 30. And all the roster points for the reserve category is filled up. That person neither dies nor gets further promotion. Suppose visualize the situation, he is neither promoted nor he is.
Because there is no place to accommodate.
So he continues in that thing for 15 years. So for the next 15 years, there will be no reservation by promotion.
It will operate slightly harshly, but that's the
I think
that is what how we'll operate.
that only I think, Mr. Mojumdar. Suppose in the initial cadre, there are 10 posts. In the promoted cadre, there are 5 posts for the reserved category. 5 have been promoted. They are neither being promoted further nor they are dying. They continue in the same position for say next 15 years.
Yes.
So for the next 15 years, there will be no further promotion by reservation.
Through reservation, yes.
As long as one of them do not vacate the post,
Yes, fine.
either he is out of service or he is promoted.
Correct. That is why Supreme Court,
So-
once the 100-point roster is filled up.
So now, suppose in the next higher cadre,
No.
there cannot be 5 reserve posts. It has to be less. It's like a
Still have
pyramid.
posts.
It's always like a pyramid.
Yes.
the lower cadre you are, the more number of posts, the higher you are, it will be lesser and lesser posts. So in the, suppose in the third level of the cadre, there are 3 posts available for reserve. So out of these 5, the only 3 will be promoted. Once the 3 promoted, 3 posts are vacated, somebody will come in. If they are not promoted, no more reservation.
No.
This
that-
came after 2012. But before 2012,
Before 2012, they would have got it, my lord, because there is a, because not by replacement, it was a running account.
so moment
My lord, I think in my written argument, I have pointed out one more fact. Earlier it was vacancy based, now it is post based. Now I'll give an example how in a vacancy based situation.
suppose in a given recruitment or promotion, there are 10 vacancies available. There you apply the reservation, say 10% for scheduled tribe. So out of the 10, 1 will be scheduled tribe.
Yes, but in a vacancy base, what happens, my lord? Supposing original.
No, in the
cadre is-
vacancy based, I'm saying.
No, in vacancy base, no, my lord. Apart from the percentage, they will get more. Because every time, my lord, there is a vacancy, they will apply the percentage of the vacancy,
That's what I'm.
not of the cadre strength.
That's what I'm trying to
Huh.
say. Suppose 10% of the cadre strength is already filled up.
Even then, my lord.
Now, a situation is arisen that 10 vacant posts have come up for
Arisen.
promotion.
Arisen, yes.
Now you again apply 10% for scheduled tribe,
There will be again one.
and out of that it will be 1.
There
So resultant situation will be 10% of the cadre is already filled up.
Yet,
You will have 1 more
one.
beyond 10%
So
because
That
of
is what
this.
deprecated in RK Sabal one.
So they will exceed their limit.
Exceed their limit,
Exceed the
percentage.
thing. So now the theory of replacement will not allow them to exceed the limit.
Exactly. Idea is it cannot exceed 50% under any circumstance. Even by applying horizontal reservation, supposing, my lord, reservation by way of, this, what we are talking of is social reservation. In a horizontal reservation, say, my lord, a person belongs to, now they call it physically challenged, handicap. Now, if already a, my lord, a particular category man is there, then irrespective of the fact whether, I mean, another is not required. Similar is the case with women reservation. If already in the scheduled tribe, say 1 woman is there, then she will not come. So idea is to protect that 50% seat.
Sorry, you was opened up a dangerous topic. Should I put you one question? What will happen when there are 2 horizontal reservations? Vertical, it's already there. 50%, 10%, 7%, 27%, OBC,
My lord,
etc.
I think horizontal.
Just a minute. Women reservation is horizontal.
Yes.
You put in 30%. Over and above that, 4% physically disabled is also horizontal. How do you fit in the second horizontal?
No, my lord, the 4% of that
No,
cadre
just a
strength
minute.
has to be worked out first.
No. Where do you fit in the second horizontal? See, this columns are there. 50%, 27%, 10%,
No.
7.5.
As far as women is concerned, there is no difficulty, but regarding physically
just
challenged.
now you apply horizontal. Across the board, you put in 30% horizontally. 30% of the 50 for a general, 30% of the 27 for OBC, 30% of the 10 for scheduled tribe. It very easily fits in. After applying this one, now you are asked to fit in physically handicapped horizontal. Where will you fit them?
And that is the situation I'll have to apply my
No,
mind.
that's why I said you opened up a dangerous topic. The question that I'll put.
That is an area I'll have to apply. But as far as women reserves, there is no difficulty.
The first horizontal, absolutely no difficulty. Where will you fit in the second horizontal? Tell me that.
Exit permissible. In that case, they may exceed also. Whether there is permissible, if it
No.
goes beyond 50%. Again,
No. Just think, where will you fit in the second horizontal? And you have to fit them. It's a statutory provision. Physically handicapped is horizontal. It's not vertical.
It's horizontal.
Where do you fit the second horizontal? Because women is already occupying the first horizontal.
As long as, for example, my lord, say in Assam, ST is 10%. Say out of 100, 10 is required to be ST. Now, supposing they're already in the cadre, there are 10 women. So there is no requirement of bringing in any women. Now again, we have to apply now. I mean, physically handicapped.
Let us take a simple model. 10 post of scheduled tribe. You put in the 30% horizontal. Three. Now you have to put in 4% physically. Where you put them?
My lord, I think literally, if
No,
there
this
are,
answer is
if
not-
there are 7 women, the 3 women as far as women is done. But how do you substitute the?
No, similarly, out of 10, 3 women is complete, 30%.
Okay.
And out of 50 for general, 15 women are there, 30% complete. Out of 7.5 of the schedule.
No, only way to look
Just,
at it is, my lord, if there are already physically challenged 4 women in the, a requisite number of women with physically challenged,
So now suppose it is not there.
not there, then they'll have to be inducted, perhaps.
Where will you put them?
So second will be slightly problematic. That we'll have to apply our mind. Anyway, my lord, I've referred to page 138. Now, my lord, will kindly come to 145. And this was an affidavit which was filed by the state at the instance of this.
Does 5A provide anything beyond that?
My lord?
Does 5A
No,
provide?
5A says it will be by replacement.
No, that is 4.
Yes.
Roman 4. Does it
Roman
provide
5,
anything
madam.
more than that?
3, sorry. replacement
3.
Three, my lord, Roman 3. Roster is to be operated on principle of replacement and not as a running account. Because running account and vacancy base was creating a lot of problem.
What is Roman 7 of 5A?
My appointment of candidates belonging to scheduled caste and scheduled tribe which were made on merit and not due to return. Yes. Yes.
This is what we understand for direct recruitment. Normally what we understand,
Direct.
this man is on merit. Once this man is on merit.
Then this will not come.
No. For the later promotion.
For later promotion, this bar of that clause 4 of 3816 will not come.
No. What I'm trying to ask you, suppose X scheduled tribe person is recruited on the basis of his merit performance. Own merit. He is not on reservation. When the time for promotion comes to the next cadre,
then he is to be treated as a general. Because he has never, got appointed against any quota.
So he
To
is
to be replaced. Yes.
in other words, he is forever outcasted from the category of of scheduled tribe.
Yes. Because my lord,
He's out.
he has because he has an identity. I am on merit.
Entering, he had a very good merit. Entrance is always academic. You hold your exams. actual work starts, he's unable to cope up with the merit. Now, will this man can stake a claim reservation by virtue of promotion because he's category wise, he's a scheduled tribe. He does not lose his scheduled tribe status.
No, in that
Only
case,
thing he entered the service through.
there I think the situation will be like this, my lord. Now supposing as a recruitment as a assistant engineer, he gets on his own merit.
Huh.
Because against his quota, another person has entered the service as a scheduled
So
tribe.
now when the time comes to promotion to executive engineer comes,
Our assistant
this
executive
man
engineer, yes,
in actual work, he's loses his merit to some extent.
yes.
Okay.
Then my lord,
And
he,
now, if you make his promotion only on the basis of merit,
Ah.
he will be at a disadvantageous position.
yes,
Now, will that man who at the time of entry had exceeded the reservation and entered on merit will be entitled to be considered for promotion as a reserved category person?
I think my lord,
Because
he
he
has
does
to be
not
counted
do,
as unreserved.
no, he does not lose his
No, my
status
lord,
as scheduled
question
tribe.
is, he's not occupying any roster point.
So it is always better if you are a scheduled tribe person or scheduled caste or reserved category person not to enter on merit.
Yes. Yes,
Moment you enter on merit, what, Mr. Betala, you are for a reserved category. What is the answer? Does he lose forever?
No, that is what.
Suppose I'm giving an example. In a given recruitment, there are 10 posts for scheduled tribe. One scheduled tribe person enters service on the basis of merit. 10 persons have entered as scheduled tribe. So now there are tribe status wise 11 scheduled tribe persons in that cadre. Tomorrow the stage for promotion comes. As a scheduled tribe person, he is entitled to accelerated promotion by virtue of reservation. Can he compete in that? Or he is forever excluded from that reservation?
On merit, RK Saparwa.
And this question, mind you, I am asking, will have a little bearing a little later on.
Yes.
That's why I'm asking.
Lord, I put it one of the paragraphs of RK Saparwal in the affidavit in opposition to that writ appeal. Lord, that paragraph of RK.
No,
Saparwal
please
says-
give a simple answer.
Yes, my lord. They will be entitled to compete on merit, my lord. They don't lose their status against the unreserved category.
Mr. Betala, you have not either not understood the question or you have not given the answer.
My lord, may I clear-
Question is very simple. Take the simplest of the case. In a given recruitment, 10 posts are reserved for scheduled tribe. 10 scheduled tribe persons are appointed by law of reservation. In that recruitment, one scheduled tribe person enters by virtue of merit. So in that cadre, for the purpose of that recruitment, there will be 11 scheduled tribe persons by tribe, by caste, or by your status. 10 on reserve, 1 on merit.
Merit.
Now the stage for the next promotion comes. The man who entered on merit, will he also be entitled to an accelerated promotion as a man belonging to scheduled tribe? Or having once entered, you are forever foreclosed from being
Competing for-
considered as a reserved category candidate? What is the answer? And mind you, think and give the answer.
Lord, to my limited knowledge of understanding what I could understand, Lord, when a person competes on merit, if he is a reserve category candidate, he competes as an unreserved category candidate. So for my lord's purpose, that these 10 persons who are reserved and the one other who
Mr.
competes on
Betara,
accelerated-
either you're refusing to understand or you're not understood.
maybe
I'm giving a very simple model. Today in 2020, when there is a recruitment for a post called X, there are 10 posts available for reserved scheduled tribe people. Many scheduled tribe people will compete for that. One scheduled tribe person enters service on virtue of his merit. moment he enters on merit, another 10 scheduled tribe person will be recruited by virtue of reservation. Fine. In this particular cadre, now there will be 11 scheduled tribe people by status. One who had entered on merit,
10 on
but
quota.
he remains a scheduled tribe. You cannot take him, outcast him from the tribe.
No, correct.
And 10 scheduled tribe who entered on merit.
Merit.
Now the stage has come for the next promotion. Say 5 posts are available for accelerated promotion for the scheduled tribe people. Can this man who entered on merit compete against those 5 posts?
That's the issue.
Or he cannot? And the answer will have a good bearing on what I am subsequently going to ask you. Think and answer.
My lord, here, when.
Don't
submitting
give,
provision-
if you are not sure of the answer, don't give the
Then
answer.
I'll refrain.
But
Then I'll refrain. We'll have a query with instructions with my senior on
you
this.
do
particular
anything
tribe.
you want, we are not concerned to where you go to get your instruction. Yes, Mr. Mojumdar, what is the principle?
My view is,
Mhm.
my view is, my lord, this, your lordship.
Suppose
My lord.
today I am a scheduled tribe.
Look, can I answer that?
Huh.
It is something like this. Let us take the example which your lordship has given. 10 reserve category, 1 on own merit.
Huh.
Say assistant engineer.
Huh.
Now, my lord, now the next level is assistant executive engineer.
Huh.
There are 5 vacancies.
5.
Now, out of this, my lord.
No, now
10
now in
I'm
the,
coming, my lord.
huh.
Out of these 10, if my lord, 5 reserve category candidate makes it, out of these 10 who are already as a reserve category, they get a
They get
promotion.
promoted. Huh.
Then my lord, he cannot come. But supposing, my lord, there are out of the 5 posts, 4 are filled up by my lord reserve category candidate, then there is still 1 post left.
One cannot be left. 10 people are there.
No, my lord, in the promotional cadre.
I understand. 10
Promotional, there are 5.
I understand. For the 5 posts, 10 people are already queuing up.
So, no, what I'm
So
saying.
there can never be 1 post left
No,
vacant.
supposing one of them do not make it.
Anyway, everybody will make it. Because 10 people are queuing up
No, my lord, what
for
I'm
5
no,
posts.
no, my lord, even among the reserve category, there will be some competition.
Understand?
Supposing, my lord, out of the 10,
Uh-huh.
if 5 makes it on merit, it's well and good. Even my lord,
The
supposing they-
merit comparison amongst the
Inter say among the reserve category. Supposing my lord 5 make it, then his case cannot be considered as a reserve category. Supposing my lord, against the 5 posts, out of these 10, 4 could make it on merit, because even among themselves also there will be interest.
So 6 are absolutely so less a merit that they cannot be
But if
promoted.
there is 4 and 1 is left, then perhaps this the person who got on his
No,
own merit.
no, you use the word perhaps. What?
No, I think his case can be considered.
No,
I think my humble understanding is, my lord,
Mr.
clause 4 is
Mr.
precisely that.
Chaudhary, we are putting this question for a definite purpose.
Yes.
If a man otherwise reserved category man enters on merit and he is,
No, I have
Just-
understood the question.
understand, just a minute. And he is forever foreclosed from competing as a reserved category candidate for further promotional benefits. If that is the principle, then if the reverse will be, if somebody had achieved the benefit of reservation to get promotion, he will also be forever foreclosed from taking anything in merit if subsequently in his career he becomes a very, very meritorious person also.
Yes.
This is why I'm putting this question. So answer will be, what will happen in the very beginning? If this man cannot be transposed to the other one and forever foreclosed, so one who is taking the benefit of the reservation, he is also forever foreclosed from coming to this side.
I think, my lord, only qualification or.
So
caveat-
this will answer your clause
No,
14.
yes, no, my lord. What I'm saying is, my lord, if in the promotional cadre, the my lord, criteria of promotion is seniority come merit. Then, my lord, the 11th person will not get any benefit. If the criteria of promotion amongst them also it is a merit come seniority, then that is also there, my lord. Merely because.
No,
it
no,
is
no, I'm not on the criteria. I'm on the,
No, but I am trying to visualize a situation.
no, no, I am on the actual answer. Will the otherwise reserved man who entered service on merit be ever eligible to take further benefit of reservation in his subsequent
Well, the
promotion?
straight answer is no, but
If it-
depending on the fact
No, no,
situation,
understand. If it is no, reverse is also no.
yes.
Then that will possibly answer your clause 14. And if this is yes, intertransposition is possible all along, then the reserved man on roster who otherwise gets promoted, in one of the promoted later on cadre, he becomes very meritorious. So he's on merit alone, he's entitled to consideration. You can bring him also. Then possibly that clause 14 will be answered.
29, 12, 14.
The one that is under challenge in this one,
Yes.
ultimately we'll have to give one answer this way or
Yes.
that way. And for any answer, we need a basis. One basis will be if a man who came out once of the reserved thing because of his own merit, if he is never allowed to go into the reservation stream for further benefit, then a man who takes advantage of the reservation stream, in spite of his higher merit at a subsequent
He cannot
level,
be permitted
he
to
also
enter the
should not
general
be
stream.
equally permitted to come back to the merit stream again.
That is one way of looking at it.
Well, my subject to correction, my view is slightly different.
Well, views will hear you, but we want the answer to this.
Well, I'm giving the answer in fact. Well, so far as this rule 5A, sorry, section 5A 7 is concerned, let me just read it once, then I'll give my answer. 7 deals with this issue.
7.
5A, Roman 7.
Appointments of can belong to merit
Yes.
and not reservation, are not counted toward reservation.
Yes.
So far as this is why this whole question struck my mind when
Because
I read
of
7
this.
only.
This is direct recruitment.
And this is so far as direct recruitment is concerned. That is
Then-
only one time.
Thereafter, lawful
Direct
kindness.
recruitment doesn't take place in every cadre.
Then thereafter, lawful kindness, in next sentence.
In
In
other
other words, they are to be treated as general category candidates, meaning thereby, so far as this is concerned, this possibly means that at the time of initial entry, if a person, although he belongs to a reserve category, if he competes with the general category and gets selected, then this person, the post which
Forever in his service, he'll remain a general category.
no. So far as this initial post which he has occupied because of his selection by virtue of being successfully on merit, he is not occupying a reserve seat. That reserve category seat remains open to be filled up by any other reserve category candidate. This is what the first part says. Then second part says, my lord, in other words, they are to be treated as general category appointment. That means he has been appointed as a general category.
Definitely.
Meaning thereby that at the time of initial entry in the cadre, if a person, although he belongs
So
to
he is now recategorized as general category.
for the purpose of his this post. Now subsequently, my lord,
Subsequently, what
yes,
happens?
I'm coming
This
to
is what
that.
I'm.
Subsequently, supposing in the next post, a promotion with exercise is undertaken. At that time, if he is my lord, able to again compete with the general category, again he will be treated to be general category. But otherwise, he will be able to occupy a
No,
reserve
this
category
is where the catch lies, Mr. Majumdar.
My lord.
To be able to compete with the general category, he'll have to wait for a few more years. But to avail the opportunity of accelerated promotion, he will get it before that stage comes.
Yes, man, he will get it.
So, understood.
as soon as the vacancy arises, that
Mr.
vacancy will be
Mr.
available to you.
Majumdar, what you were saying is,
Fine.
this man on the next promotion will compete on merit. If he is unsuccessful, he'll come back to the reservation stream. But difficulty is, he will be entitled to the reservation stream at a period prior to being considered on merit, otherwise on merit as a general candidate, because this is accelerated promotion.
Yes, ma'am.
If as a general candidate,
yes,
he
ma'am.
will
Prior,
be
you're absolutely right, ma'am.
considered after 5 years.
Yes.
For accelerated, he will be considered after 4 years or 3 years. So that situation will not come at all for this man. The question whether he will be considered for reserved or not
Yes.
will have to be determined at a stage before he will be otherwise considered on merit as a general candidate.
My lord,
Will you allow him or you will not allow him?
should be allowed, my lord. He should be allowed. My lord, I'm just giving it in a.
No, we don't know. Should be, we want, basically want a clear stand on that.
We are only discussing, I'm again just trying to put it across my own. Supposing after he's initially appointed, now a few vacancy has arisen. Again, as the amendment says, the reservation is not post-based, not vacancy-based, it is post-based. Now, considering the number of posts available, if 2 of the posts are reserved for ST, and this man belongs to ST, then he can always be considered for this ST vacancy. And if he cannot compete there, if otherwise he's, if supposing he is unable to get himself selected through this reserve category, but otherwise he has competed with the general category and he has got selected, he can always be promoted by being a general category candidate. This is what I'm saying, ma'am.
I understand what you're saying.
And because of this,
basically my whole purpose was, is the interchangeability between general and reserve for a person which otherwise belongs to a general category is permissible. If the interchangeability is permissible, maybe at a later stage when the man has acquired promotion through reserved means, found eligible on merit, he can again change over, but that will be again subject to one more aspect, because his initial things were done without merit comparison earlier. That is another point he has raised. We'll go into that. Otherwise, minus that part, interchangeability is permissible or not?
Interchangeability possibly will not be permissible.
If it is not permissible, then the clause 14 is right.
My lord, a general category
If
candidate,
interchangeability is permissible, we'll have to examine under what circumstance it is yes and what circumstance it is no.
interchangeability is permissible for the reserve category, but not for the general category. General category cannot in any case.
Where do you get that?
Well, I'm coming to that, madam. A general category candidate cannot claim a post reserved for the reserve category.
No, where do you get that?
The rule itself says it once it is.
Where do you get that a reserved man will always have the benefit of any time coming over this side?
No, it's not a question of coming out. It is not necessary that
He
he should
definitely
come.
is coming out. By virtue of what is prohibited in clause 14, if a man who had availed accelerated promotion earlier, in one of the subsequent cadres, higher cadre, he suddenly becomes eligible on merit, he'll also go and compete in merit. This is what is prohibited in clause 14, and that is under challenge. So that means this man is interchanging from reserve to non-reserve by virtue of being on merit at a higher level, when for the lower levels to reach that level, he availed a reservation. But if interchangeability is not permissible at all, so we are asking the rudimentary question, what about the first cadre? A man who enters on merit is permissible. He is otherwise a reserved category man. If he is forever, he is foreclosed from taking accelerated promotion by virtue of he having entered in merit, then interchangeability is absolutely impermissible. Then at a later stage also, we can take the same analogy and say that it is not permissible. But again, if interchangeability is permissible at a lower level, for a man who entered on merit, otherwise reserved, come and compete in the reserve stream for further promotion, then he can always go out of it also later on, if he again attains the merit. In other words, two parallel lines are there. You have entered one, another has entered one. If interchangeability is absolutely impermissible, you remain in the parallel line of merit general all along. You can never think of coming this side. If that is so, a man of this side also can never think of going that side. On the other hand, if from the very initial stage, this crisscross is permissible,
My,
at a later stage also maybe
my
allowed a crisscross.
possibly I have not been able to convey. Basically, possibly the question of crisscrossing will not come. Supposing, my lord, in a promotional cadre, there are 5 vacancies. Now, out of that, 2 are reserved for any particular category of reserve category person. Now, 3 are open. Now, when the DPC takes place, in the DPC, if a reserve category person can be selected on merit, then he does
Sir,
not.
Majumdar, think about it. Think about it. Now
Yes,
you're
let us think it
basically,
over.
Yes,
huh,
yes.
because if it is absolutely not permissible at any stage,
But
the higher stage also why you permit it? If it is permissible, then we'll try to understand under what circumstance it is yes and what circumstance it is no.
So, my lord, a question may arise. A person belonging to, it's a loud thinking, my lord. He is hired on merit, therefore he enters service. Now he, as far as direct recruitment, he enters as a general, unreserved. Now tomorrow, when it comes to promotion by virtue of his merit, even amongst the reserve category, then he would be senior most. Because in any case, his position would be above. The reserved one's name would be down below.
Definitely.
Now then, my lord, whether he loses his identity or he will retain it. That's the issue, my lord.
Basically, that
is
is,
the
issue.
Because
If he is forever foreclosed from coming to the reserve stream again, because initially being reserved, he entered on merit,
my lord,
then I think at a higher level also you
that
should not
issue,
allow to go
that
that
issue
side.
does arise for consideration in this case, my lord, may not be.
Yes, the clause 14. Clause 14 is a man who availed the reserve stream.
Clause, 1.11.
No,
Clause
not
4,
on one
clause
point.
4, and there is clause 4.
Four, sorry.
Huh.
He had availed the reserved stream. At a higher level, he suddenly becomes very meritorious. Now he's trying to compete and come this side also. That is the bone of contention, whether
Yes,
it can be done or not.
Precisely, that is what is not being permitted by clause 4.
Clause 4. So we are studying the validity of clause 4. If this way it is impermissible, from right to left you are not permitted at
And
any
from
stage.
left to right also.
From left to right also, why should it be permitted?
Right.
And if you are permitted from right to left, then maybe you will have to see whether at that
From
stage
left to right
left to right is permissible or not. This is what.
Well, no, we'll apply our mind to that aspect. Get back
Otherwise,
to-
how do you decide this one?
Right.
There is no other criteria to decide. Because Mr. Vitala will say with all strong words that it is justified, and Mr. Sharri says, no, it is not so. And we are in a precarious condition.
My lord, we'll fix a date, my lord.
When do you want?
Tuesday, my lord.
Huh?
Tuesday.
That would be out of station till next week. But I'll pray for Wednesday or Thursday or any day, not Tuesday. Wednesday.
I was thinking of getting rid of this
Even,
matter, but earlier also.
See, till the finish of these matters. It's continuing for very long a time.
His leave of absence is still 10.
Sorry.
his leave of absence is till 10th of this month. After 10th.
No, we'll hear the others, at the end we'll hear him. That doesn't mean everything has to be foreclosed because one person is not there.
That is the Thursday one.
Yes. Will you be comfortable on, if his lordship appears on the virtual mode?
No, not difficult with me.
No.
Sorry, what to-
No
don't worry.
difficult.
Foreigner, I come to foreigner now.
That's the next thing.
It will be quite interesting then. Proxy will be
He will
there.
be out for 2 weeks, that's why I
Fine.
am saying.
Lots next week. Oh, acha.
He will out for 2 weeks. On 8 anyway, we are having a DB with his lordship through virtual mode
Yes.
for some other matter.
That FT man.
But that matter, I think is almost completed, so nothing
yes,
much
yes,
will
yes.
be there.
Yes.
But here it is going
I
on.
can conclude on that day, Mike.
Shall we experiment that the video mode or we wait till after 2 weeks?
Considering the nature of the matter, it would be better.
Fine.
Well, a video mode, we can appreciate for some,
Best is
not for full scale hearing.
these matters,
be honest.
you finish it off.
Ah.
If it is in favor of Mr.
No,
Chaudhary,
but I
Mr.
have the benefit of reply.
No. If her judgment is in favor of Mr. Chaudhary, Mr. Betala will go to challenge it. If it is in favor of Mr. Betala, Mr. Chaudhary challenge it. This is a foregone conclusion. So let us take a call either way. And you get it tested in the Supreme Court and that will be the finality in this matters. Otherwise, it's hanging around for a long time now.
That case will have great
Sorry.
accommodation for my senior.
Sorry.
Because on the 8th, he will not be there. Senior. Mr. Dikedas won't be there on 8th. Can it be
He can also join in on video mode.
Yes, he'll be out of station at.
Doesn't matter. Anywhere within this planet, he can come in video mode.
the
Country also
briefs-
doesn't
briefs
matter.
will not that-
Sorry.
So the nature of briefs will not involve in this matter. But these are around 20 matters.
While advocate can scan all the pages and
Well,
send it to him.
That Hercules task.
Or matter, let us have it after the meeting.
Nee, হেৰি কৰি
After the meeting.
5 তাৰিখ 5ৰ পিছত হেৰি হ'ল 12 19 we commencing 19th সেইটো এটা প্ৰব্লেম হৈ যাব না 19 June
Fine.
Well,
heard Mr. Ken Chori, Senior Counsel for the petitioner for the applicant in WA so Mr. Mojumdar and Mr. Betala.
19.
Mr. Chaudhary, by referring to the OM dated (29 12 2014) comma more particularly clause 14 thereof has raised the contention that all the that as all the existing orders on the subject are deemed to have been amended by the OM of 29 12 2014, therefore even the provision of the OM dated 12/3/2002 providing for consequential seniority had also stood amended. I think this is your core argument. Heard in part, hearing remains inclusive, list for further hearing on 19/6/2023. Tuesday কৰিব নেকি? Monday কৰিব, start কৰিব, 19/6/2023. Come prepared, finish it off. Whatever you want to argue.
Deep.